And hello, everyone, and welcome to the Prof Show. We are here tonight to discuss the trial of Richard Allen, or to be more specific, the appeal of Richard Allen. And we've been going through this appeal of Richard Allen step by step, episode by episode. In tonight's episode, we are talking about the infamous probable cause affidavit written by Tony Liggett, being the first portion of the appellate filing for Richard Allen. We're going to be discussing all the problems with that search warrant application or affidavit. And there's a lot of problems with it. It's full of lies and omissions, misrepresentation of witness statements, and all of that. So that's the topic for tonight. So if you're new here, welcome on in. And I hope you get educated a little about this case and about the core issues regarding this appeal of Richard Allen in the Delphi murders case. So that's the topic for tonight. Happy Friday night, everybody. And give me a moment. We'll be back after the music. And we're going to dive really deeply into this fallacious search warrant affidavit. So you don't want to miss it. Welcome, everyone. Please get yourself situated for a lengthy deep dive into the appeal of Richard Allen.
It was our job to help law enforcement.
Is a fucking terrorist, a fucking pedophile, sympathizing fucking terrorist.
Not productive. It's kind of gross and icky.
Prof is a fucking terrorist, a fucking pedophile, sympathizing fucking terrorist.
It's not productive. It's kind of gross and icky.
It was our job to help law enforcement.
It's not productive. It's kind of gross and icky. And I feel like it tells us more about them than the people they're trying to degrade. They're always trying to degrade someone. It's not productive. It's kind of gross and icky.
It was our job to help law enforcement.
This is bullshit, Alado.
It was our job to help law enforcement.
It's not productive. It's kind of gross and icky.
Prof is a fucking terrorist.
It was our job to help law enforcement.
All right, enough of all that. Enough of that. So welcome in. Happy Friday, everybody. What's up, Deb? Deb's pointing you to my link tree. If you need to get in touch with me or want to support me in any way and all the good stuff, check out the link tree. It's in the description. I want to welcome everyone in, especially a court of public opinion. Left some good comments there. I see Christina's here. Brittany Renee, pardon me, Digital. Arthur Claremont. Who's her daddy? Pertinent. We got Dewey here. Kay's here. Anarch 00141 leaving some nice comments. Nicole Watt, Sweet Southern. Who else is in here tonight? Rebecca Ann. Okay. Mustang. What's up, Mustang? Criminal Sociology, KB. We got 4 pit bulls across America. How's the volume? Is it any better? Okay. Who else we got in here? Monday. David Rogers. Hello, sir. Ninja Warrior Assassin. How are you? And Critter Mama. Hey, Critter Mama. We got well, several others who I've probably missed because I'm having trouble seeing the little text there. But welcome to everyone. Happy Friday night to you all. Let's see. Oh, there we got Erica here. Hello, Erica. Hey, Brittany Renee. We got Court of Public Opinion reminding you all to like, subscribe, comment down below, especially if you're on the replay. So yeah, welcome in everyone. Appreciate seeing you here. I'm sure we'll talk later. So I think it's been a week since I've seen you all, and I've had quite a week, but I'm telling you, the more time goes by and I observe, the more appalling this all gets. You know what I'm saying? And I don't even know where to begin. Well, I mean, I'll cover several bases, I guess. First of all, the lying bloodluster, methed out, pedo enabling, guilter demons out there, they just don't know when to shut up. You know, I've noticed they obviously they're highly anxious about this appeal that's underway, revealed by their behavior online and their insistence on producing content which is solely, I guess, aimed at licking the asses of the cops involved in this and the prosecutor and all those who pulled off the unthinkable by really trying to railroad this guy. And like I said before with Richard Allen, I think that the intent was to force him to confess or to force him to take a plea deal, which is why they did all they did pre-trial. And then it was obvious when trial was approaching that they were intent upon railroading him on through the system, which is why they needed a judge to facilitate that. They needed jurors who were compromised, and they needed a clerk who was compromised. They needed cops and security guards who were compromised, just like they needed a bunch of prosecutors, a bunch of expert so-called witnesses, and and a bunch of trial witnesses who were all compromised. And I know you'll say, or they will say, do you realize what it would take for a cover up of these proportions? Do you realize what it would take for all these people to work together to do this? Yes, I do. Yes, I do. But it's clear that even though it's obvious that it would take a lot of effort to pull off uh, something like this, it's obvious it happened. And for those who are the bloodluster, bloodthirsty, blood drinking, bloodletting, uh, bloodluster, methed out, pedo, filthy demons from Indiana, um, they tend to suffer from this problem with critical thinking, or I don't know, maybe you call it a wishful thinking cognitive dissonance. In other words, oh, the cops say he did it, so he must have did it. But they will overlook all the most egregious shit that you've ever seen. They will overlook the fact that there was nothing to this case. I mean, the let's call a spade, or whatever. Let's call out the obvious, right? So they will look at this case, which was entirely circumstantial. So you had a case with zero evidence. Okay, zero evidence. And they will say, "No, there's evidence. There's a bullet." No, the bullet is bullshit. Okay, the bullet is absolute bullshit. And if you want to know that, inform yourselves on the science of ballistics, on the approach that was used in this particular case, on the obscene facts of the quote unquote matching of this bullet to this individual's gun. And the moment that you become educated and inform yourself on that, you will instantly know that the bullet is bullshit. It literally, it truly is a magic bullet. And honestly, I think it was planted. If it wasn't planted, it was, well, it was definitely found later than they say and differently than they say. It might have been from a cop's gun or somebody in the neighborhood's gun. Uh, there's zero evidence that makes this Richard Allen's bullet. Okay, in other words, they will tell you that they literally had to fire a bullet in order to match the extraction marks of a bullet that was unfired. So, first of all, that is cognitive dissonance there. It makes no sense. How do you, how on earth do you have to fire a bullet to get a marking on an extraction marking on a casing that matches one that was not fired? It literally makes no sense. And they would say, well, because of the forces involved. Well, hold on. Why didn't Richard Allen then have to fire it to get those same forces? Are you saying that he's 10 times stronger than any of the men in that ballistics lab? Are you telling me that since it was a woman over the stuff, that she's too weak and frail to rack the gun appropriately? She could not have found the nearest big ass dude and say, "Hey, man, bro, can you please extract this for me? Can you just rack this gun real hard for me, like the hardest you possibly can?" She couldn't have tapped Brad Holder on the shoulder and said, "Hey, Brad, hey, bud, I know we're all brothers and all. Can you come over to the lab, and we're trying to frame this guy Richard Allen? Can you come and rack this gun real hard and see if we can get some extraction marks that match the unspent round from his gun? Can you just come rack it hard since you work out every day and all this stuff, and your adrenaline's through the roof?" No, no, nope. They had to literally fire it. And then if you take that damn bullet and you look at the microscope or the photography of these striations or extraction marks, they call them, and all the scratches, and you try to match them up, you will literally see that it's not a perfect match. And you would think that this is going to be like a fingerprint. You're going to have to get a damn good positive, I don't know, what, 80% or higher to say it matches. But no, of course, this person here, the prosecutor allows her to say, and the judge allows her to say, she's never been wrong. And that at most, she might get a 2% positive, but she's never been wrong. It's total bollocks. Okay, not only that, they'll say, well, you know, uh, there's evidence. There's evidence. Well, what's the evidence? Because we all know there's zero evidence. Zero evidence. Zero. All the evidence is circumstantial at best. In other words, hey, he was around that area that day, and we know there were about 20 other people around that area that day, which would probably include at least 12, 10 to 12 other men. But we're going to ignore all those 10 to 12 other men who were also there at that place at that time. And we're going to solely focus on this one man, ignoring all other 10 or 11 of them. And we're going to totally omit the fact that it could have been a female who did this or was involved in this, as we had many indications in the years leading up to the arrest of Richard Allen that a female was involved. We know there was a female hair found in the victim's hand, one of the victim's hands. Oh, we're going to ignore all that. We know we had a confession from a female who said she stabbed regarding the girl with the female hair in her hand, we had another female who said that she stabbed that particular girl to see what it felt like. But, we're going to forget all that. And so they're going to say, no, none of that ever happened. We've never considered a female. Why would a female ever kill another female? And then they're going to say, oh, yeah, and by the way, we're absolutely certain that this guy in a video that we have created as somewhat of a phantom, an anonymous, a faceless monster named Bridge Guy, a character in this horror phantasmagoria. We're going to call this individual Bridge Guy, and then we're going to now declare that he killed the girls, although there's no evidence of him killing the girls. There's zero evidence that this individual in the footage or photography from the victim's phone actually perpetrated a crime against the girls. Well, we have no evidence of that. We've lied about the evidence all these years. We've destroyed a large amount of evidence. We once claimed there were fingerprints, and of course now we say there's no fingerprints. We claim there was DNA, but we say we can't match the DNA. We got DNA, but we can't match the DNA. We've got DNA in the sexual organs of the girls. Oh, can't match that either. We got DNA all over the bodies. Can't match that. We've got female hairs. We can't really say that was involved in anything. It probably came out the laundry of some unlaundered clothing. We've got multiple confessions from at least 5 different people over the years that are far more substantial than Richard Allen's psychosis-induced confessions. Oh, and by the way, they'll say, well, but he confessed. Yeah, but they'll ignore the fact that he confessed under a period of psychotic breakdown in the midst of deep psychosis and forced medication of antipsychotics. Yeah, he confessed to the crimes. And by the way, that they'll also ignore the fact that he confessed to elements of the crime that don't even match reality, at least according to the prosecutor. So yeah, he said he shot the girls. He said he's sorry for shooting both of those girls. He said he shot the girls with his gun, but apparently he didn't know how the girls were killed, because turns out they weren't shot. And then he'll say, oh, he apologized for raping the girls, but then they'll admit, or they'll try to claim, oh, the girls weren't raped. So okay, yeah, so he confesses to shooting because he thinks the girls were shot, but of course they weren't shot. Then he confesses to raping, apologizes for raping, but then it turns out that the state claims no, they weren't raped, although there is, for lack of a better term, male seed in these girls. There's male DNA all over the girls, but they claim they can't match the DNA, can't match any element of the confessions to the crime except just the fact that he killed them. And then they send in this extortionist therapist to go in there and feed him information that she's obtained by being an insane podcast fangirl of this crime for years. And in fact, 3 hours a day in traveling to treat the guy or extract information or feed information to him, she's listening to these podcasts by all these bloodlust or guilty demons. And so they'll say, no, there's all that. And then you'll say, well, but okay, where's the evidence that this guy did this? Oh, well, it's not the evidence. I mean, it's clear that Bridge Guy killed the girls, even though there's no evidence of that. And then they'll say, and it's clear that Richard Allen is Bridge Guy, although there's no evidence of that. And then they'll say, so it follows that Richard Allen killed the girls, although there's no evidence of that. And then you sprinkle in a mix of a bunch of lying ass witnesses and witnesses who've been coached and aspects of their stories left out and aspects of their stories compelled to be changed by the various prosecutors. And you end up with this, I don't know, this clusterfuck. I mean, there's no better way to say it. And so you look at these people and you say, what's the evidence that this guy is guilty? Well, all of that, the totality of all of that. We have the totality of the plate of bullshit that you just served up. And then they'll ignore the fact that this guy was absolutely egregiously railroaded. So not only was his pretrial detention literal, it was a literal human rights violation. If you take this to any human rights organization around the world, any human rights organization would agree that that guy was the victim of flagrant human rights abuses and torture and inhumane treatment in violation of his human rights, according to any organization around the world. They'll ignore that. And then you look at this trial and you say, well, yeah, but in the trial, the judge did not allow a defense whatsoever. They lied. Okay. The prosecutors and the cops all lied in different ways. The various witnesses all lied in different ways. The judge sustained nearly every objection the prosecutor made. And then blocked Richard Allen's attorneys at every step of the way, tripped them up, blocked, roadblocked, sidelined, even attempting to throw them off or have them withdraw their representation with Richard Allen, strong-armed them, okay? And in the meantime, as trials going on, you get a bunch of meathead white supremacist fucking pricks riding around intimidating all of the defense team, all of the defense investigators, and the defense contingent of advising attorneys and employees of the defense. Okay, they ignore that ever happened. And then, most of all, they ignore the fact that we all online have been threatened with death. CPS has been called. We've been swatted. We've been threatened with bodily harm. We've suffered extreme psychological harm. We've had our employers called. We've had our family members called, and we've been literally stalked in person and stalked through the U.S. Postal Service, and they'll ignore all that. But these same people will say he's guilty as hell. Remember Jody Williams and communicating with one of these idiots named Fig Solves, who just had to see fit to double down on his gaslighting that Richard Allen is definitely guilty. Yeah, he's definitely guilty, and I want him to suffer. I want him to pay the price for what he did. Yeah. The clerk of court, the employee of the judge, who was feeding all the bloodlusty guilt or demon asshole shills inside information while doubling down on his guilt. Have you watched the Alex Murdaugh appeal be underway? Isn't that kind of what the clerk in that case was doing? Right. Wasn't she inappropriately discussing that guy's guilt, even with jurors? Hey, I wonder if some of that happened with Delphi. Pretty sure. Like, what happened to this jury? How was the jury hung at 4 not guilty, and somehow those 4 flipped instantly. Of course, everyone's been threatened with death. Everyone has been intimidated beyond what should ever be socially acceptable. The dickheads have gotten away with murder, basically, because you got to consider this. If Richard Allen was not involved in this crime, had nothing to do with it, then that means the killers are walking free, which is what we believe, which is the absolute most obscene part of all of this. That not only do you have some guy that you railroaded on through the system because you thought that that was the way to get it done, but you've got those 2 victims, little girls, whose killers are walking free, being protected by the cops and the elected officials in that region. Why? Is this what it took? Is this what it took? Is whatever you're trying to hide so damning that it took all of this, that all of this was worth it? What happens when it comes to light, all that you did? Do you think it'll never come to light? Because there is the probability that some of it, at a minimum, will come to light. What are you going to do then? See, we paid the price on the front end. And they had the nerve to say, the YouTubers, they just need to, if you have a problem with Richard Allen being convicted, then you just need to leave the country. And don't do any more podcasts, those mean YouTubers. And then they say, Richard Allen, he shouldn't appeal. He shouldn't appeal. He needs to let those families rest. He needs to let those girls rest in peace. He shouldn't appeal. Shouldn't appeal. Don't appeal. Don't appeal. Don't appeal. Do the right thing. Don't appeal. So you see what I mean about what kind of ride this has been? And hey, I haven't even brought up the dead bodies. You know, not the 2 girls. I mean, all the other individuals who've died in the course of all this. Of course, they're going to say that never happened. It's not related, blah, 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 blah. How many YouTubers dead? I can think of one who blew his wife's face off and then blew his own off and left behind a little baby. I can think of another who went in his garage, blew his head off for some unknown reason. Oh, I can think of a few others who got killed in different ways by cops and by accidents over the years. Of course, that never happened. Oh yeah. What about the prosecutors or the prosecutor who resigned? What about the judge who recused himself? What about the state police superintendent who pussied out after this was all done, after he made sure it happened? Resignations, recusals, murders, suicides. Are we going to say that never happened? Yeah, probably. Probably. But that's what we're looking at. That's what we're looking at. And I'm saying, wow, what would be worth all this? What would be worth all this? Yeah, sorry, four puts. I left out fires. Far be it from me to omit the obvious here. Fires. All the people burned alive, just barbecued in their homes. You know, ones who knew the insides of this case, you know, like polygraphers. Gang members, human traffickers, meth traffickers. But yeah, we're just going to ignore all that too and just look the other way. But my question or my challenge to you guilters out there, you people who believe everything you're spoon fed, even if you believe Richard Allen had something to do with this or was guilty of killing these girls, even if you believe that, do you believe in the way it was done? Do you honestly believe that the way it was done is justified? And that's an honest question for you people. If you can be honest with yourselves, even if, can you condone the way that this was done? You know, I mean, like by lying about Kathy Shank finding this tip magically. Yeah, that was proven. By lying and about the phone of the victim and what was on it and what wasn't and deleting shit. Yeah, that was done. By throwing this pretrial detainee guy into solitary strip cell confinement for the longest possible time until he literally mentally broke down, thought he was God, thought he was Satan, thought he was in heaven, thought he was in hell, thought he was King Michael, thought he was starting World War III, eating his own feces, smearing it all over himself, beating the shit out of himself, masturbating, singing national anthem, well, everything else, right? Confessing to shooting the girls, saying that he's being tortured and poisoned, and then being medically or forcibly injected with antipsychotics. But you got dickheads out here who will say, but he was faking. Whoa, hold on. He's faking. Well, if he's faking and the doctors are injecting him with antipsychotics more than one time on a repeated basis, then okay, so which way is it? Is he faking and then the doctors are committing crimes and are going to lose their licenses for medicating him when he's faking? Or is he truly ill and being medicated for that and then not faking? Because you can't have it both ways. You can't say, no, that doctor was perfect. She should have been injecting him with Haldol. But no, at the same time, no, he was faking, totally faking. But you can't reason with these people. They literally believe that everything was on the up and up. Richard Allen should have been thrown in the worst place in Indiana. He should have been thrown in there where actually convicted felons go. Yeah, he should have been put in there. And he should have been put in there, 13 times, oddly enough, the policy limit for solitary. Yeah, he should have been put in there that amount of time. And yeah, he should have been threatened with death to him, his wife, his mother, and his daughter. Yeah, that he should have been. Yeah, he should have been eating his own shit and drinking his own urine, and he should have been uh, uh, beating himself up, and because all of this was necessary to get him to confess, so that we could secure a conviction and get justice for Abby Lemon. Really, really. So by any means necessary, in other words, so if you end up in prison, if you end up accused of a crime, then all of that should be on the table for you. That's what I'm trying to understand. Are we saying it's okay? This is all okay? This is all on the up and up. So those who are giving a thumbs up to this, what has truly transpired. Look, what I'm saying is not a fabrication here. Okay, I'm telling you literally what happened. So we're saying that all that was done to Richard Allen is totally legitimate, totally on the up and up, totally approved by the people of Indiana. It's a good thing to do. People of the United States of America love this type of treatment. As a matter of fact, if it'd be your son, your brother, your cousin, or fucking you who end up in a similar position, then you believe it would be okay to throw your ass in solitary confinement for 13 months as a pretrial detainee, and you believe it should be okay to let you mentally deteriorate to the point where you're being force medicated, you're having man down incidents, you're seeing God, you're banging your head on the wall, you're eating your own shit, you're getting laughed at, you're getting shock vest, and the odinous freaks in the prison are threatening to kill you, your wife, and your mother, and your daughter. If you would just confess. We're saying it's okay that so you end up in a situation that you should be beat, tortured, starved, neglected, locked away until you have a total mental breakdown. We're saying that's okay. Those are good tactics to use. In other words, this is Guantanamo Bay, Indiana. That's okay. Guantanamo Bay is cool. We should waterboard every accused criminal that enters a prison system. Hey, I got a new rule for it. How about we make a new constitution? Constitution for the United States of Indiana. Okay, and it's going to start like this. When you're accused of a crime, you're allowed to be tortured, threatened with death to you and your entire family, sextorted, force medicated, manipulated, framed, convicted. Fuck, why do we even have fuck the judge, fuck the jury, fuck the executioner. Can't we just have whatever old cop they want to just say, hey, that guy's guilty, I'm judge, jury, executioner, and just shoot him in the head? You could let's get Richard Allen over with. So new rule for Indiana, okay? We'll this will be like a what do you call it? This will be a pilot project. We'll call it the United States Constitution of Indiana, USA. And it'll go like this. When you're suspected of a crime, especially if they need to cover some shit up and bury the case forever, the cop will be able to come up to you. He'll say, you're guilty of this shit, and I'm a fucking prove it. And then he can pull out his gun, put it to your head, and just blow your head off. And we'll call that a pilot project. This is the new pilot program for Indiana. It's called Judge, Jury, Executioner. Criminal Justice in Indiana, 2026. We're making waves. We're going to transform the system. This is called Criminal Justice Reform 2026 in Indiana. And that's the precedent you're setting. Oh, and I forgot to mention the 40-pound drop in weight. We're going to make sure you starve too, so that you tank 40 pounds in the first 5 months. I'd say that. How about we do this to you? Instead of judge, jury, executioner, let's take it in 3-month increments. So the first 3 months we'll be throwing you in, letting you drop those 40 pounds while getting shocked and poisoned and threatened and abused. And then the next 3 months, we'll let you go into a deep psychosis, and we'll send in like a blonde with fucking cleavage and some perfume that smells like roses and shit or whatever. We'll let her go in and rub your leg and tell you everything's going to be okay if you just say this. Okay. And then we'll leave you in another 3 months. And for that final 3 months, I guess then we'll start injecting you with the shit. And letting you eat your own, feces and stuff, because we won't feed you. We'll just let you do that. And as soon as you start beating the shit out of yourself enough and confess, then we'll let the executioner kick in, and we'll let that same dirty ass cop come in and take care of you. And we'll call this the 2026 Indiana Criminal Justice Reform Pilot Program, based on the precedent set by the treatment of Richard Allen in Westville and the railroading of Richard Allen in the Allen County Superior Court. And we'll call it Justice for Libby and Abby. And all the bloodlusty CI guilter demons who sleep with their cousins, breed with their sisters, and stuff like that, they'll be ecstatic. It'll be ecstatic. And look, this will be great political points, because then we'll let everyone who did this run for office. We'll let them all run for office. So, everyone involved in this pilot program, they're going to do the pilot program for a year, and then they're going to run for office after you're dead. How about that? And we'll say thanks to what happened to Richard Allen, this is the new way things are going to be done around here. And I'm sure they'll get elected right on in. They'll be voted right on in. And then they can make the laws even worse and they can do more damage. So I would suppose that must be my pent up aggression and critical thought on this entire fiasco. Which, I guess I've blown 40 minutes of a rant here. 40 minutes of your valuable time you'll never get back. But promise, we'll get into the program now. I want to say thank you to Swade Smith. Swade Smith gave a 99-cent super sticker. Thank you, Swade. Swade Swade Smith, why don't you do a super chat? That way you can say something. I want to put it on the screen. Say something, Swade. All right. So it's just kind of infuriating because of all the shit I see. Because I see people online, they say like, "Oh, he's a monster. He deserved everything he got." And the defense attorneys, Andrew Baldwin is a liar. Everything he's put up has been a lie. Really? Lie? Oh, okay. Okay. So you saying that the entire, let's call it Ferenczi Murphy click report, right? You're saying that's entirely made up by Andrew Baldwin? Sure. And you're saying that everything that Reese Davis heard from Ron Logan and Keegan Kline, that is confirmed by other individuals who spoke with those individuals, all of that confirming information, you're saying that all of that is bullshit too, although it's vetted by other individuals in direct contact with both of those individuals. Sure, right. And Andy Baldwin made that all up. Sure. Okay. But these people, it's like wishful thinking, because they want to look at this and they want to see, is this being the right thing that was done? But they don't want to admit that this was done the wrong way. And that's what's insane. It's like, can't you just admit the truth? Can't you look at this and say this should have never went down like this? No, but they can't. They can't look at this and say that this should have never gone down this way. Because by doing so, they'd have to admit error. And for them to admit error is beyond them, because they're not reasonable people. They're not humble people, and they don't literally think, and they never make mistakes. So I've just refused to even continue to address them. But I got to say, it's disheartening, and it's just bewildering. Like, how in the world can you motherfuckers run around the earth thinking in that way and carrying on in that way and not understand what's wrong here? And they will justify every single criticism, no matter what it is that we point out. And hey, I could understand, let's say if we're pointing shit out and it's 50-50, half of the time they can agree that, yeah, good point there, maybe you're right, that was fucked up, that was wrong, that shouldn't have went down that way, and yeah, that should be rectified. Nope, they can't admit it, not half the time. And you'd say, well, maybe 70% of the time. Nope. They cannot admit 70% of the time. They can't even admit that 30%. They can't admit that 30%. Well, every once in a while, yeah, that was kind of fucked up. You've pointed out 100 issues. So yeah, I'll admit that 30 of them were fucked up. Nope, nope. So then you say, well, maybe 90% of the time, I they can deny it 90% of the time, and then 10% of the time, you would think, okay, out of 100 criticisms, maybe they'll admit that 10 of them have some substance. Nope, 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 nope. They're not living in the same reality as everyone else. And when I say everyone else, I mean pretty much everyone else. Because you got your dumbasses who just, they see this guy was arrested, they see he was convicted, they're good with it, whatever. They don't know the case at all. But for anyone who has some sort of, I don't know, orientation on this case, you'd say at least, come on, man, at least 2 to 3% of the time, give me the, give it to me. At least 2% of the time. Let me be, you can deny the criticism 98% of the time, but come on, 2% of the time, can't you admit you were wrong, or y'all were wrong, or they were wrong 2% of the time? Out of 100 criticisms, can't you give me 2? Nope, nope, nope. But you know what they'll do? They'll scrub the internet of everything that would prove them wrong. Say like those crime scene photos. The crime scene photos everyone should see, because they will prove to your eyes that there are sigils left on those bodies at that crime scene. And there's zero explanation why Richard Allen would ever even know what a sigil was, much less be able to form them onto bodies. Why leave a crime scene like that with those sorts of signatures? That one lousy fucking prosecutor who resigned, he even denies that he ever said that there were non-secular. Complete denial of reality, which is why they whitewash, they dirty delete, they scrub the internet. If you don't realize that something's wrong here, then you need to look a little deeper, because something is wrong here. And it might seem like I just mentioned the entire set of issues. No, I haven't. I haven't. There's so many issues. I could sit here for 6 hours. I mean, we got the 2 a.m. blood curdling screams with one of the girls who heard those get her head blown off days later. I could go down the list of YouTubers who were at the crime scene on that day. Yeah, but they won't admit that either. You had that whole search party the morning, just coincidentally at the exact same time that phone is connecting with the tower in the 4:30 a.m. range. You actually have the first searcher showing up with the film crew. You remember that? Yeah, well, forget about that. That never happened. You got all the other 40 caliber bullet casings and shit that was found right at the scene and in that entire area. They deny that ever happened. Complete denial of the destruction of the marathon footage, which would have proven a couple things. Yeah, complete denial of that. Complete denial that Mike Patty was one of the sketches. Complete denial that in 2019 they announced, and by they I mean the state police of Indiana announced that, hey, by the way, these two sketches, it's two different guys. This one guy, he ain't the guy. Okay, this new guy we're showing you now, who is actually the first guy, yeah, now he's the guy. They're two different people. But now, yeah, years later, we're going to make them the same again. I mean, and the list goes on and on and on. Oh, we don't want to talk about the sister deleting shit off the girls' apps and shit, but we don't want to talk about that, and we don't want to talk about the people hacking Keegan Klein's emails and I mean accounts and all this shit. And we don't want to talk about all the shit that happened in the week before. We don't really talk about that, and we don't want to talk about the connection to Florida. No, we're not going to talk about that. And yeah, and you can go down the list, and it's just hundreds of issues. Every one in itself is alarming. Complete denial of reality. No, we don't want to talk about the parents. Yeah, we don't want to talk about who brought the girls around the day before or whatever. We know we told lies about that, and the story's always conflicted. We don't talk about that. Yeah, we don't want to talk about the drug dealing dad and all the shit and the hits and the and we don't want to talk about the CIs, all the informants, and we don't want to talk about how the dad was an informant, and maybe like maybe a couple others were informants, and maybe a couple of the parents, and we don't want to talk about none of that. We don't want to talk about nothing, 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 nothing. Richard Allen's guilty. If you don't like it, leave the country. And especially don't want to talk about the money. I see that's being brought up in the chat. Yeah, the money. They don't want to talk about the money. They don't want to talk about the money. They don't want to talk about the defense attorneys' money. They don't want to talk about the fundraiser money. They don't want to talk about the Patty's fundraisers money, right? They don't want to talk about the ballpark's money. They don't want to talk about the millions of dollars the prosecutors raked in. They don't want to talk about all of the PR firms that were hired over the years. They want to talk about none of the money, none of the auditing, none of the endless cycle of bike rides and the millions of dollars and millions upon millions of dollars. So you see what I mean when this there's so many layers to this. Oh yeah, good point. Four pits is on a roll. They don't want to talk about the conflicts of interest. You know how the prosecutor is related by marriage to one of the victims. No, we don't want to talk about that. We don't want to talk about Kathy Shank's family's relationship with Ron Logan. We don't want to talk about Ron Logan's relationship with the Kleins. We don't want to talk about the Kleins' relationships with this one and that one and all these. We don't want to talk about other people in the household, if you get what I'm saying. We don't want to talk about none of that. No. Richard Allen's guilty, and if you don't like it, leave the country. Oh, yeah, we especially don't want to talk about purging the discovery. Yeah, we don't want to. Oh, we also don't want to talk about Reese Davis's letters. No, not at all. We don't want to talk about how it's just coincidental that the one letter Reese Davis sent that had Keegan Klein's letters in it. Oh, that just happens to be the one that the prosecutor can't find and never received. Although it was shown that it was sent out. No, never received that one because it has Keegan Klein's letters in it. Don't want to talk about it. The Snapchat murders, right? The Snapchat murders. Catfishers, catfishing. We won't talk about that. The Dropbox. Never happened. We don't talk about that. Lured out to the trails that they don't talk about that. Mm-mm. The sleepover. No, don't talk about that. The pig roast. No, don't talk about that. The CPS building. No, don't talk about that. Don't talk about Elvis Fields or Brad Holder or Patrick Westfall or Anna Williams or Eric Williams or Adam Bridge and Joseph Bridge. No, don't talk about none of that. And let's not talk about all the other POIs, the Paladinos and the Praters and the oh shit. Just let's not talk about that. Let's not talk about the McCains. Let's not talk about the refurbishing of the trails and that whole thing, that whole scam. No, no, don't talk about none of it. Don't talk about geocaching, please. We do not want to talk about geocaching, especially the one that, that's what we were doing that week. Did I just say that? Yeah. So this is why it's important to talk about this appeal, because let's be honest here. We got 3 issues on the appeal. Okay, let's put this into focus. 3 issues on the appeal of Richard Allen. We just covered about 300 issues. So the potential 300 issues that we should be discussing, we're only talking about 3. In prior episodes we covered issues 3 and issue 2. Tonight, we are here to cover the first issue. So out of hundreds, we only get 3. So the way this is going to go down is we're going to take a look at what we're actually talking about. And what we're talking about is the probable cause affidavit. Okay, now keep in mind, because I know this might be pretty unbelievable to you all. There are several versions of this. You can't make it up. Can't make this shit up. There's several versions of this. Although this is the one that is in the appellate appendix, volume 2, as you can see, page 103. So this is your official version, although we got several versions, all differing slightly. There's anomalies. Okay, a question for you in the chat. Are you aware that there are several versions that differ of this particular document? Another issue. But like I said, because this is the version that is referenced in the appellant's brief, we'll look at this one because this is your so-called official version. So I think it's important that we take a fresh look at this to understand what it says, because I know many of us, we haven't really looked at this since right after Richard Allen was arrested. But we'll take a look at this before we get into the appellate opinions on this, okay, or arguments. All right, so just a moment. Let me see. We'll pull this up. Okay, so I guess I got to be a nerd on this. We're going to nerd out on this, geek out on this real quick. So I'll save my commentary for after, but the first thing I want to point out before we go forward is the very first sentence before the narrative here. Notice this, okay? Notice this. that the hearsay statements of witnesses contained herein are considered reliable and credible due to the witness's personal knowledge and are corroborated by the totality of the circumstances. Remember, this concept of the totality of the circumstances is key to making Richard Allen the criminal in this matter. Remember, not only are we framing it this way as we introduce the probable cause affidavit, remember Mike Patty, Becky Patty. What did they say in their first interview after the conviction of Richard Allen? Well, what was the one thing that convinced you that Richard Allen is guilty? Um, uh, it's not really one thing. It's the totality of the circumstance. And what did McClellan say in his? The totality of the circumstances prove that Richard Allen is bridge guy, and bridge guy killed the girls. Therefore, Richard Allen killed the girls. A totality. All these people are real big on the totality. So here it says, and I'm sorry this is going to be difficult because it's long, but that on February 14th, 2017, victim 1 and victim 2 were found deceased in the woods at approximately 0.2 miles northeast of the Monon High Bridge in Carroll County. Their bodies were located on the north side of Deer Creek. At the time, the Monon High Bridge Trail was an approximately 1 mile gravel trail terminating at the Monon High Bridge. Monon High Bridge is an abandoned railroad trestle approximately 0.25 miles long, spanning the Deer Creek and Deer Creek Valley on the southeast end of the trail. Approximately 0.7 miles northwest on the trail from the northwestern edge of Monon High Bridge is a Freedom Bridge, which is a pedestrian bridge spanning State Road 25, approximately 300 feet west. Sorry, I'm looking at the chat. Approximately 300 feet west of Freedom Bridge was a former railroad overpass over Old State Road 25, also known as County Road 300 North. Yeah, that's where Richard Allen actually parked, but we'll get back to that later. The trail terminates just west of the former railroad overpass. The majority of the trail is in a wooded area with a steep embankment on the south side of the trail. The entirety of the trail and the location of the girls' bodies were and are located in Carroll County, Indiana. Through interviews, reviews of electronic records, and review of video at Hoosier Harvest Store, investigators believe victim 1 and victim 2 were dropped off across from the Mears farm at 1:49 p.m. on February 13, 2017 by Kelsey German. The Mears farm is located on the north side of County Road 300 North near the entrance to the trails. A video from victim 2's phone shows that at 2:13 p.m., victim 1 and 2 encountered a male subject on the southeast portion of the Monon High Bridge. The male ordered the girls, "Guys down the hill." No witness saw them after this time. No outgoing communications were found on victim 2's phone after this time. The bodies were discovered February 14, 2017. So there's already anomalies. There's already anomalies. You see, you know how you're hitting on all cylinders when they come in with the bullshit? So I'm just gonna take care of a couple pieces of shit here. All right. All right. Already some anomalies here. In order to do a deep dive on these anomalies, we'll have to do an A/B comparison with the various versions of this thing. Okay, because there are various versions. They're all different. Can't make it up. Okay. The video recovered from victim two's phone shows victim one walking southeast on the Mona High Bridge while a male subject wearing a dark jacket and jeans walks behind her. As the male subject approaches victim one and victim two, one of the victims mentions gun. No, they don't. That's a falsehood. Near the end of the video, a male is seen and heard telling the girls, guys down the hill. No, the guy's not seen. You see what I mean? Thank you, MJ Lewis. MJ Lewis with the super chat. Thank you. Listen. So there's two lies there, okay? First lie, gun. No one says that be a gun, okay? There's no mention of a gun at all. There's no sound of a gun. There's no mention of a gun. That is a fabrication. Okay, so first lie, gun. Second lie, the video, near the end of the video, a male is seen and heard telling the guys down the hill. No, there's a male voice heard saying guys down the hill. The male voice is not seen saying guys down the hill. So two lies. The girls then proceed down the hill and the video ends. I would also say that's a stretch because the girls don't proceed down the hill. There's no video evidence of that on the video we've seen. What it appears is one of the girls directs her body toward what looks like a heading down the hill. So the girls don't seem to begin to proceed down the hill. The man is not seen telling the guys down the hill, and there's no mention of a gun. Also interesting is what's mentioned here is a dark jacket, a male subject wearing a dark jacket. Not blue, not a blue Carhartt, but a dark jacket. Okay, let's continue. Victim one and victim two's deaths were ruled as homicides. Yeah, no shit. Clothes were found in the Deer Creek belonging to victim one and two, south of where their bodies were located. Okay, that's called, Reese Davis says, Ron Logan threw the shit in there because he bled on one of the victim's clothes. There was also a .40 caliber unspent round less than 2 feet away from victim two's body, between victim one and victim two's bodies. The round was unspent and had extraction marks on it. Okay, do you see the planting of the seed here? Why mention extraction marks, okay, at this point in the narrative? So what particular purpose does it serve to insert the phrase and had extraction marks on it? Because what it could have said is there was .40 caliber unspent round less than 2 feet away from the victim two's body, between victim one and victim two's bodies. The round was unspent. That's all it had to say. It also should have said, and it was found later on. But of course, it doesn't say that. It omits that, and it adds, and had an extraction mark. Interviews were conducted with 3 juveniles, Rayleigh Voorhees, Bree Wilbur, and Anna Spath. They advised they were on Monon High Bridge Trail on February 13, 2017. They advised they were walking on the trail toward Freedom Bridge to go home when they encountered a male walking from Freedom Bridge toward Monon High Bridge. Anna Spath described the male as kind of creepy and advised he was wearing like blue jeans and like a really light blue jacket. And his hair was gray. Gray. What? Maybe a little brown. And he did not really show his face. His hair was gray. Sounds like, is that John? Is that McCain? Hair was gray. Was Richard Allen's hair gray? Okay, moving on. She advised the jacket was a duck canvas type jacket. Rayleigh Voorhees advised she said hi to the male, but he just glared at them. She recalled him being in all black. Okay, so now it's not blue, now it's all black. Oh, so yeah, blue. So let's go back to Anna Spath. Blue jeans and light blue jacket. Okay, blue jeans, light blue jacket with gray hair. Girl right next to her, right, advised he's in all black with something covering his mouth. Not very tall with a bigger build. He was not bigger than 5'10". Rayleigh advised he was wearing a black hoodie, black jeans, and black boots. Well, that doesn't sound like blue jacket and blue jeans. She stated his hand in his pockets. So far we got kind of creepy. Okay, think about this. Why insert the phrase kind of creepy in this paragraph? Kind of creepy, description 1. Also, glared at them, description 2. Kind of creepy, glaring. Although blue and blue and black and black. Okay. Bree Wilbur showed investigators photographs she took on her phone while she was on the trail that day. Well, I guess that proves her story. Her photographs included a photo of the Monon High Bridge taken at 12:43 and another one taken at 1:26 p.m. on the bench east of Freedom Bridge. Bree Wilbur advised she took the photo of the bench. After she took the photo of the bench, they started walking back toward Freedom Bridge. She advised that was when they encountered the man who matched the description of the photograph taken from victim 2's video. Bree Wilbur described the man she encountered on the trail as wearing a blue or black windbreaker jacket. She advised the jacket had a collar and he had his hood up from the clothing underneath his jacket. She advised he was wearing baggy jeans and was taller than her. She advised her head came up to approximately his shoulder. Well, how tall is Bree Wilbur? I mean, there you go. That's how tall is Bree Wilbur? In 2017, that her head would come up to his shoulder. She advised Rayleigh said hi to the man and he said nothing back. So far, kind of creepy. He glared and said nothing back. She stated he was walking with a purpose, like he knew where he was going. Okay, now walking with a purpose. So now we're developing a profile, okay? Kind of creepy, glaring, said nothing back, walking with a purpose. And this is all going to matter later, because if you listen to the trial and listen to Nick McClelland's bullshit gaslighting ass, he incorporated all of this into his fantasy world, right? All of this is the fantasy. He's just a man walking with a purpose, glaring back, looking kind of creepy. Interesting to note here that Bree Wilbur is shown, okay, the bridge guy image, and then says that the man she encountered matches that. So now we're showing the witnesses bridge guy and saying, is this who you saw? So they can say, yeah. And we'll get further confirmation of that because that's what they did with others. Let's go keep going. Let's see. She stated he had his hands in his pockets and kept his head down. She advised she did not get a good look at his face, but believe him to be a white male. The girls advised after encountering the male, they continued their walk across Freedom Bridge and the old railroad bridge over Old State 25. Investigators spoke with Betsy Blair, who advised she was on the trails February 13, 2017. Video from the Harvest store captured Betsy's vehicle traveling eastbound at 1:46 p.m. toward the entrance across from the Mears farm. Betsy advised she saw 4 young juvenile females walking on the bridge over the old State Road 25, and she was driving underneath on her way to the park. Betsy advised that there were no other cars parked across from the Mears farm where she parked. She advised she walked to the Monon High Bridge and observed a male matching the one from victim two's video. Okay, so now Betsy Blair is also shown the image of the bridge guy so that she can confirmation bias that's who I saw. Okay. She described the male she saw as white male wearing blue jeans and a blue jacket. So now we're not in black. We're not in all black anymore. Now we're back to blue and blue. Now we're in all blue, not all black. She advised he was standing on the first platform of the high bridge, approximately 50 feet from her. She advised she turned around at the bridge and continued her walk. She advised approximately halfway between the bridge and the parking area across from Mears Farm, she passed two girls walking toward Monon High Bridge. She advised she believed the girls were victim one and victim two. Believed. Video from the Harvest store shows at 1:49 p.m. a white car matching Kelsey German's vehicle traveling away from the entrance from the Mears farm. Betsy advised she finished her walk and saw no other adults other than the male on the bridge. Her vehicle was seen on Harvest store video at 2:14 p.m. leaving westbound from the trails. Betsy advised when she was leaving, she noted a vehicle was parked in an odd manner at the old Child Protective Services building. She said it was not odd for vehicles to be parked there, but she noticed it was odd because of the manner in which it was parked back in near the building. Investigators received a tip from Terry Wilson, in which he stated he was on his way to DELPHI on State Road 25 around 2:10 p.m. on February 13, 2017. He observed a purple PT Cruiser or a small SUV-type vehicle parked on the south side of the old CPS building. He stated it appeared as though it was backed in as to conceal the license plate of the vehicle. Betsy and Terry both drew diagrams of where they say the vehicle parked, and their diagrams generally matched as to the area the vehicle was parked and the manner in which it was parked. Wesley McWhirter advised he remembered seeing a smaller, dark-colored car parked at the old CPS building. He described it as possibly being a smart car. McWhirter's vehicle is seen leaving at 2:28 p.m. on the Hoosier Harvest store video. Now, stop there. You guys ever driven on Old State Road or State Road 25? You know it's a highway, right? You know you're doing a good clip down that highway. You know it's kind of far to look over and see that CPS building or where it was. So just saying from a realistic perspective, when it comes to Terry Wilson, how can he fucking remember a random car he passed as he's on a random highway, probably driving 55, 65 miles per hour? That part just seems like, I don't know, Terry. I don't know. But you can see what's being done with this paragraph. Liggett is taking all of these vehicles and trying to meld them all into Richard Allen's vehicle to shove that square peg into that round hole and make Richard Allen's vehicle be that, and he the only one out there. Therefore, he killed the girls. Now, you'll notice what's omitted is that Betsy Blair described this car as, first of all, not black, and secondly, like a 1965 Mercury Comet, one similar to which her father owned when she was younger. We'll get to that later. Investigators spoke with Cunt of the Week, Sarah Carbaugh, who stated that she was traveling east on 300 North on February 13, 2022, and observed a male subject walking west on the north side of 300 North away from the Monon High Bridge. Sarah advised that the male subject was wearing a blue-colored jacket and blue jeans and was muddy. False. You guys already know. Tan-colored jacket and was muddy. She further stated that it appeared he had gotten into a fight. Investigators, well, where's the slaughtered the hog? Bloody like slaughtered hog. Investigators were able to determine from watching the video in the Hoosier Harvest store that Sarah Carbo was traveling on County Road 300 North at approximately 3:57 p.m. Okay. Here's what they omitted as well. And this is for you new folks. Do you know how they identified all of the various vehicles? Kelsey German, Betsy Blair, Sarah Carbo. You know how I identified those vehicles? They basically took screenshots of the various vehicles and handed them to the people and said, "Oh yeah, look through these photos. Tell me if you see a car." So in other words, Kelsey German identified her own vehicle. Sarah Carba identified her own vehicle. Betsy Blair identified her own vehicle. Wesley McWhirter identified his own. Shit, I think the only guy that didn't identify his own vehicle is Richard Allen. Oh, but forget about that. It never happened. So you've seen all the narrative building here. Now it says, so, and through interviews, electronic data. What electronic data? Photographs and video from Harvest Store, investigators determined that there were other people on the trail that day after 2:13. Those people were interviewed, and none of those individuals encountered the male subject referenced above, witnessed by the juvenile girls, Betsy Blair and Sarah Carba. Further, none of those individuals witnessed victim 1 and victim 2. Okay, so nobody witnessed victim 1 and victim 2, except you add in the Betsy Blair believes she may have seen victim 1 and 2. And I'm going to skip this part because they go through the so-called tip that Richard Allen was interviewed in 2017, and there's this narrative. We'll skip that. Investigators believe Mr. Allen was referring to the former Child Protective Services building, as there was not a Farm Bureau building in the area, nor had there been. Mr. Allen. Investigators believe the females he saw included Rayleigh Voorhees, Bree Wilbur, and Anna Spath. Why are they leaving out? Oh, fuck it. Come on. You see, in this tip where Mr. Allen was interviewed in 2017, he saw 3 females. Well, notice what Liggett is doing here. He's listing 3 females: Rayleigh, Bree, Anna. Who is he leaving out? The 4th one? Investigators believe Richard Allen owned 2 vehicles in 2017, a 2016 black Ford Focus and a 2006 gray Ford 500. Investigators observed a vehicle that resembled Allen's 2016 Ford Focus on the Harvest Store video at 1:27 p.m. traveling westbound on County Road 300 North in front of the Hoosier Harvest Store, which coincided with his statement he arrived around 1:30 at the trails. Investigators note witness described the vehicle parked at the former Child Protective Services building as a PT Cruiser, small SUV, or smart car. But why did you leave out 1965 Mercury Comet? Notice the omission. PT Cruiser, yeah, that could be a 2016 Ford Focus, I suppose. Small SUV, I guess you could call that, that could be a 2016 black Ford Focus. A smart car, I guess that could be a 2016 black Ford Focus. Oh, I noticed a curious omission, and that is a 1965 Angular, not black, Comet. Where is it? Oh, you're trying to mislead the judge. I see. You're trying to force the square peg into the round hole. I see it. Okay, never mind. On October 13th, 2022. October, is that another 13? Damn, we got 213, right? We got 13 months, and now we got October 13th. Oh my God. October 13th, 2022.
This is bullshit, Alado.
Bruh.
October 13th. No coincidence in that. Richard Allen was interviewed again by investigators. He advised he was on the trails February 13th, 2017. He stated he saw juvenile girls on the trails east of Freedom Bridge, and he went onto the Mona High Bridge. Richard Allen further stated he went onto the Mona High Bridge to watch fish. Later in the statement, he said he walked out to the first platform on the bridge. He stated he then walked back, sat on a bench on the trail, and then left. He stated, and you know what? He said he smoked a fucking cigarette. Okay? That's what he said. He stated he parked his car on the side of an old building. He told investigators he was wearing blue jeans and a blue or black Carhartt jacket with a hood. False. Okay. Another obscene falsity. He did not say he was wearing a blue or black Carhartt jacket with a hood. He didn't. Outright lie. Is that about the third or fourth one we've already gotten a couple omissions. Now we're about the third or fourth lie, right? He advised he may have been wearing some type of head covering as well. He further claimed he saw no one else except for the juvenile girls he saw east of Freedom Bridge. He told investigators that he owns firearms and they are at his home. What about Betsy Blair? You know, if Richard Allen is saying, like, think about this. If Richard Allen is stupid enough, if he's guilty, right? And he's stupid enough to say, oh, yeah, I was there that day. You know, I was wearing the same shit as Bridge Guy. Oh, yeah, by the way, I went out onto the bridge, you know, where this witness says she saw yeah, I was on the bridge that day. Yeah, I parked over there where you said where Doug Carter said he was seeking information on a vehicle. Yeah, you know, I'm very well at this case. I mean, matter of fact, I've Googled it a few times. And I'm going to put myself there at the scene of the crime. And I'm going to put myself there at the time of the crime. And I'm going to put myself in the same clothes and on the same place on the bridge at the same time and all this happens. I'll put myself there in every way. And I'll even say I saw some girls who saw me. But for some reason, I'm going to leave out the old lady. I'm going to leave out Betsy Blair. Why didn't he, if he's telling enough of all that shit to implicate himself, why wouldn't he say, hey, I saw Betsy Blair. I saw this lady when I'm standing on, I'm standing on the first platform of the bridge, and I saw this old lady look at me. I saw this lady look at me, kind of like squinting, looking at me, and then she turned around. And you notice Richard Allen doesn't say anything about seeing Betsy Blair. No one finds that strange. Okay, so first of all, he says he sees 3 girls. We know there's a group of 4, but he says he sees 3. He doesn't see Betsy Blair. So in Richard Allen's telling of this, where is Betsy Blair and where is the 4th girl? So now we got 2 missing people from his telling of this. Betsy Blair and the 4th girl. Kind of odd. Richard Allen's wife, Kathy Allen, also spoke to investigators. She confirmed that Richard did have guns and knives. Oh my God, guns and knives. Not like every man. How dare anyone own a gun or a knife? I mean, United States of America. Let's see. Second Amendment. Let's see. There's also knives are not illegal. I think most men in the United States of America own a knife, at least. As a matter of fact, most adults in the entire world own at least a knife. Okay, so Richard Allen has knives. And he potentially has guns. She also stated that Richard Allen still owns a blue Carhartt jacket. Oh, but he omits the fact what he should have said is she stated Richard Allen owns a blue heart jacket that was purchased approximately 2019 or 2020. It's odd that you didn't mention that. You tried to frame this in a way to imply that it's the blue Carhartt jacket that he admitted to owning and wearing, and that makes him therefore then bridge guy. And then that fact that she says that he owns a blue Carhartt jacket means it's the murder jacket. And look, let's be honest here. Okay, pause on the PCA. You guys are aware, right, that the vehicle of Richard Allen was forensically tested for blood and DNA? You are aware of that, right? And are you also aware that the blue Carhartt jacket, you know, the one purchased in 2019, 2020 that is used here in this PCA? Yeah. You realize that was also tested, right? And do realize that everything he fucking owns was tested, right? You do realize not one drop of blood, not one shred of DNA, not a single drop of blood, not a single shred of DNA or hair or fiber from Abby or Libby at all whatsoever ties to Richard Allen. Not a single drop of blood in the car, although he's muddy and bloody like he just slaughtered a pig and got in a fight. He slaughtered a hog. He's so muddy and bloody that Sarah Carbo can identify that he has just murdered 2 little girls and slaughtered a hog. And he gets in his car, but magically, he doesn't leave a single drop of blood or a single piece of DNA or a single hair or fiber, nothing. Furthermore, this blue Carhartt that he's allegedly wearing, absolutely pristine, clean, not a single fiber, single hair, single drop of blood, single piece of DNA, nothing. And on top of that, no digital forensic evidence, no messages, no following one of the girls on Snapchat. No, we got a whole other bunch of pedophiles. Okay, let's be honest here. We got a whole bunch of pedophiles, and we got a whole bunch of local guys that were connected to these victims on social media. And I mean on Instagram, on Kick, on Snapchat, on Yellow or Yubo. We had a whole bunch of fucking predators in Indiana living in that county who were connected to our 2 victims, but not a single connection of Richard Allen physically or digitally to these victims. Of course, they're going to ignore all that, right? On October 13th, investigators executed a search warrant of Richard Allen's residence at 1967 North Whiteman Drive, Delphi. Among other items, officers located jackets. How dare he? Boots. Oh, what are you thinking? Knives. Oh my God, he's the killer. And firearms. That's the one he must have been the reason the girl said that be a gun. Between October 14th and October 19th, 2022, the Indiana State Police Laboratory performed an analysis on Allen's Sig Sauer model P226. The laboratory performed a physical examination and classification of the firearm, function test, barrel, and overall length measurement of test firing, ammunition, component characterization, microscopic comparison, and NIBIN. The laboratory determined that the unspent round located within 2 feet of victim 2's body had been cycled through Richard Allen's Sig Sauer model P226. An identification opinion is reached when the evidence exhibits an agreement of class characteristics and a sufficient agreement of individual marks. Sufficient agreement is related to the significant duplication of random striated patterns or impressed marks as evidenced by a correspondence of a pattern or combination of patterns of surface contours. The interpretation of identification is subjective in nature and based on relevant scientific research and the reporting examiner's training and experience. Ain't that a bitch? Do you see what that caveat is? In other words, all bullshit. Sufficient agreement related to the significant duplication of random striated marks. Subjective? Is your mind starting to open a little? Investigators then ran the firearm and found that the firearm was purchased by Richard Allen in 2001. Oh my God, what a criminal. He actually purchases his gun legally, probably uses an FFL, does it the right way, legally purchases a firearm. And you're saying he uses it to kill 2 girls, right? In the commission of this crime. And you're saying that he doesn't go throw it in the Wabash River? Really? So he doesn't go throw it in the river. He just decides he's going to keep this gun that he used to facilitate the murder of these 2 girls. That's how stupid he is. Just like the Carhartt, he's not going to go burn the Carhartt. He's not going to go dispose of the Carhartt, go sell it somewhere. He's not going to go throw it in a river. He's not going to go sell the gun. He's not going to go throw the gun in the river. Really? Richard Allen voluntarily came to the ISP post on October 26, 2022. He spoke with investigators and stated that he never allowed anyone to use or borrow the Sig Sauer Model P226. When asked about the unspent bullet, he did not have an explanation of why the bullet was found between the bodies of victims 1 and 2. No, that's not what happened. It's not that he did not have an explanation. Why not quote what he actually said? Because this implies guilt, and what he said does not imply guilt. He again admitted that he was on the trail, but denied knowing victim 1 or 2. Well, that should be fact because there's nothing proving that he ever knew those victims, and denied any involvement in the murders. Now, here's where it gets rich. Detective Liggett has been part of the investigation since it started in 2017. He's had an opportunity to review and examine evidence gathered in this investigation. Detective Liggett, along with other investigators, believe the evidence gathered shows that Richard Allen is the male subject seen on the video from victim 2's phone who forced the victims down the hill. Further, that the victims were forced down the hill by Richard Allen and led to the location where they were murdered. Through statements and photographs of the juvenile females and the statement of Betsy Blair, Rayleigh Voorhees, Bree Wilbur, and Anna Spath were at the southeast edge of the trail at 1243 east of Freedom Bridge at 126 and walked across the former railroad overpass on Old State Road 25 after 126 and before 146. They walked the entirety of the trail and observed only one person, an adult male. Yeah. And how many do we know? We know for sure there were more than a dozen people out there that day. But these girls only saw the one, and it has to be Richard Allen with gray hair and in all black, but also in all blue. And they reiterate the blah, blah, blah with the quack, quack, quack with Betsy Blair's vehicle and the girls and the similar clothing, da, 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 da. And everybody saw the same guy as Richard Allen. Okay. And they say everything matches Richard Allen. The girl saw Richard Allen. The clothing he said he was wearing matches. The vehicle matches. No other male subject matching his description was seen on the trail after 2:13 p.m. Bullshit. How many guys were out there after 2:13 p.m.? I'm thinking of one right now that looks identical to the sketch of Betsy Blair. Can anyone want to volunteer? Who was that guy that looks identical to the sketch of Betsy Blair who was out there after 2:13 p.m.? Oh, yeah, that never happened either, right? Investigators believe Richard Allen was not seen because he was in the woods. Yeah, that's a big belief with victims 1 and 2. Okay. The bullet found was forensically determined to have been cycled through his gun, which is entirely subjective based on randomized striations, right? Richard Allen stated he had not been on that property where the unspent round was found, that he did not know the property owner, and he had no explanation as to why a round cycled through his firearm would be at that location. He stated he never allowed anyone to borrow or use it, Investigators believe that after the victims were murdered, Richard Allen returned to his vehicle by walking down 300 North. He was seen by Sarah Carball walking back to his vehicle with clothes that were muddy and bloody, but we can't explain where there's not a drop of blood or a shred of DNA in his car, or not even mud. Car is pristine. But yeah, of course, he got into that car muddy and bloody and somehow avoided the harvester camera. By the way, what? How in the world? There's okay, for you newbies, there's cameras all the way around that building in 2017. Okay, all the way around that building, there's cameras. How does Richard Allen, muddy and bloody, after just murdering 2 girls in a frenzy, how does he walk back to his car? Muddy and bloody, like he just slaughtered a pig, got in a fight. How does he not show up on that camera, or not that camera, on that footage that surrounds that building? He's nowhere to be found on any of that footage. Come on. So this individual somehow makes it back to that car over there where that car is supposed to be, allegedly, never passes a camera in that entire building. Is covered by cameras, never passes a camera, gets in his car, muddy and bloody, somehow doesn't leave a drop of blood in the car. Come on. Is any of this possible at this point? Tony Liggett, along with the other motherfuckers, believe the statements made by the witnesses because the statements corroborate the timeline of the death of the 2 victims as well as coincide with the admission made by Richard Allen. Furthermore, all these lying-ass witnesses are similar in nature, and timestamps and photographs taken by Bree Wilbur correspond to the times the juvenile female said they were on the trail and saw the male individual. Investigators believe Richard Allen committed kidnapping, which resulted in the killing of victim 1 and 2. From their prior conclusions, investigators believe Richard Allen was the male depicted in victim 2's video saying, "Guys down the hill." They believe Richard Allen was carrying his Sig Sauer model P226 on that day due to the cycled round matching subjectively with randomized striations, the firearm that was located within feet of the victim 2's body. They further believe he was carrying the Sig Sauer model P226 from the audio from victim 2's video, in which investigators believe they heard the sound of a gun being cycled. Bullshit. I've done thorough audio analysis. It's the sound of leaves crunching under your feet. It's not the sound of a gun racking. And one of the victims mentioning a gun, no one mentions a gun. Again, I've done very comprehensive audio analysis on that video. You put in the earbuds, you listen. The word gun is not mentioned. No one says that be a gun. What is said is, this is the path that we go down. So more lies. Anyhow, there you have it. And based on this, State of Indiana by Nicholas McClellan, prosecuting attorney, files probable cause affidavit executed by Tony Liggett and information for count 1 murder felony, count 2 murder felony. The defendant being in custody, the court determines that probable cause does exist. The court sets bond in this matter at $20 million cash or corporate surety. Benjamin Diener signs off on this. Remember, the very next thing Benjamin Diener did was he wrote Tony Liggett, I believe it was. Wasn't it Tony Liggett or was it Tobe? He writes the request for safekeeping order totally illegally. He writes it, hands it back to the guy. The guy signs it, hands it back to him. He issues the order. Benjamin Diener then immediately resigns, or I'm sorry, recuses himself. Can someone explain that? Totally corrupt. Totally corrupt. You've never seen anything like this in your life. Total corruption on display. Look at the date at the top of the screen. October 27th, 2022. Now, what they will say is that when Richard Allen came in, they didn't intend to arrest him. They didn't intend to go have to do this, right? That what they intended, I think, strategically, they thought he was going to come in and give them permission to search, right? But let me ask you this. Do you really think that all of this was done in a matter of a couple of hours? I mean, take a look at it again. Okay? Take a look at it. Like I said, there are several versions of this, but October 27th, right? October 27th. All right. This was all a plan. This was all a plan. They had this thing ready to go. So when they called Richard Allen in to come get his car, they had this 8 pages ready to fucking go. Because the first attempt was going to say, hey, man, can we have permission to search your home? Can we have permission? And they thought he'd be stupid enough to say, oh, yeah, sure. But they had this on the side ready, right? So they had this thing, and they said, oh, he's going to be belligerent, and we're going to have to arrest him. He's not going to allow us. Okay, I guess we'll just go get this damn thing. Okay. And I believe what they did, they had it all ready to go. So when he came in and he said, yeah, I don't know, I was probably wearing a jacket or something, whatever I normally wear. I own a bunch of jackets. I own a bunch of pants and shoes. I mean, I was wearing my clothes. I'm not sure. So then they said, gotcha, bitch. And then they go and they stick that in there, right? And whatever else he might have said, the little tidbits he gave them in the course of that interrogation, they went shove that on in there. But that thing was already ready to go. Anyhow, so we're going to do now, this is the appellant's brief, okay? As I mentioned, this is part 1 of the appeal, okay? Issue number 1. So we'll hurry through it, because that took a lot longer than I thought. But issue number 1, okay? We've already been through issues 2 and 3. Issue number 1 here is the trial court committed reversible error by admitting evidence seized from the unconstitutional search of Allen's home. Okay. Trial court committed reversible error also by denying a Frank's hearing. Okay, so that's 2. The trial court committed reversible error by admitting evidence seized from an unconstitutional search and denying a Frank's hearing. When reviewing the admission of evidence after a denial of a motion to suppress, the court considers evidence favorable to the ruling and uncontradicted evidence to the contrary. Factual findings are reviewed for clear error, but the constitutionality of a search is reviewed de novo. Allen filed a motion to suppress, a motion for a Frank's hearing, amended request, and a lengthy memorandum with exhibits. The trial court denied the motion and hearing, concluding Liggett's affidavit did not include false statements or omit facts with reckless disregard or intent to mislead. The trial court erred by concluding Detective Liggett did not make false statements or reckless omissions in his affidavit. Both the state and U.S. constitutions guarantee that no warrant shall issue but upon probable cause supported by oath or affirmation. The state must include all material facts in a warrant application, including, and now I'm going to focus on my highlighted portions here, including facts that cast doubt on the existence of probable cause and a source's reliability. Okay? So the state must include facts casting doubt on the existence of probable cause. And what would that be? That would be something like this. A 1965 Mercury comet being the vehicle that Betsy Blair witnessed. A source's reliability. That would be like this. Sarah Carba changing her story 3 fucking times over the years. A warrant is invalid if 1, the police omitted facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading. Now you see how generous that is? Let's go back to these 2 points. What makes a warrant invalid? Number 1, if the police omitted facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading. So in other words, it doesn't have to be proven that Tony Liggett omitted certain key facts with the intent to mislead, right? It only needs to be shown that the Carroll County sheriffs acted with reckless disregard in assembling this probable cause affidavit as to whether it would be misleading. So was it reckless to disregard the fact that Betsy Blair said she saw a 1965 comet, one similar to her father-owned, that was not black? Is that reckless to disregard that and then omit it? Next point. The affidavit supplemented with the omitted information would have been insufficient to support a finding of probable cause. In other words, with what you have omitted, would that cast doubt on whether there was probable cause? The defendant must prove reckless or deliberate false statement by preponderance. Okay, here's another thing. This does not have to be established to the court beyond a reasonable doubt. This only has to be established by a preponderance of the evidence. So, by a preponderance, could it be established that there was recklessness in disregarding whether the omission of this information would make the probable cause affidavit misleading? And my answer is yes, because we're not having to prove this beyond a reasonable doubt or that there was intent to mislead. You only have to show that it was somewhat reckless to disregard this about whether it might be misleading, and we just have to show a preponderance of evidence to that effect. And I think that is met in this. Now, here gives a little definition of or example of what would be reckless disregard, which we're looking at here. If the officer withholds a fact in his ken that any reasonable person would have known that the judge would wish to know. So let me ask you this. If you're the judge who has to sign off on this, would you want to know that Betsy Blair described a vehicle that was extremely different from Richard Allen's vehicle? Wouldn't you want to know that? Because remember, in the probable cause affidavit, what was included were all the vehicles that might be mistaken for Richard Allen's vehicle. So in other words, oh yeah, a smart car, or yeah, a PC Cruiser, oh yeah, a small wagon type vehicle or whatever, small hatchback. All those vehicles that might be mistaken for a vehicle similar to Richard Allen's, oh yeah, he included those, made them all one. The one vehicle he omitted was the one that absolutely would not be mistaken by Betsy Blair for Richard Allen's vehicle, because the fact that you would mistake a 1965 Mercury Comet for a 2016 or whatever Ford Focus, it ain't going to happen, especially when she says that vehicle she saw that was a 1965 with sharper angles was not black. Richard Allen's vehicle was black with rounded angles. It don't make sense. That was omitted, and that was withheld. And remember, this definition here says if it's withheld, that and it's something that any reasonable person who's the judge would wish to know. Furthermore, this also goes to facts and details that undermine the officer's conclusion or assumption or wishful thinking. So you need to include things that the judge, a reasonable person, would wish to know, even if it undermines your conclusion. Detective Liggett omitted and changed key information that undermined his conclusion that Allen was bridge guy. Okay, which goes to the point we just read. Okay, details that a reasonable person or the judge would wish to know. Liggett misled the court in 4 ways. And here we're going to go through the 4. Liggett misled the court to believe that Betsy Blair's description of the man on the bridge matched Richard Allen when it did not. Liggett told the court that Blair said the man was standing on the platform wearing a blue jacket and jeans. But Liggett omitted the rest of it, that the man had brown poofy hair like the sketch below and was in his 20s or 30s, youthful and medium build. So what did Detective Liggett do? He withheld this detail, a detail that any reasonable person who's a judge would wish to have known. He misled the court that Allen's car was parked at the old CPS lot. Liggett told the court that after Blair saw the man on the bridge, she saw 2 girls she thought were Abby and Libby. As Blair's leaving, she saw a car parked in the same general area and manner. Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted the fact that Blair said the car she saw during the time was not black and had sharp angles like the sketch below. And here is her literal sketch. Considering the omitted information that the car was not black and had sharp angles like a 1965 Mercury Comet, Blair naturally excluded Richard Allen's black hatchback. This is a material omission. Thirdly, Liggett misled the court that the man walking on 300 North was Bridge Guy. Liggett falsely told the court, that means lied, that Carbaugh in 2017 claimed the man was muddy and bloody wearing a blue jacket when she actually said his jacket was tan and he was muddy. A bloody man in a blue jacket matches Bridge Guy. A muddy man in a tan jacket does not. Furthermore, Liggett also admitted that Betsy Blair told him that the man she saw on the bridge was not the same person Sarah Carbaugh described. As I mentioned, Indiana State Police even released a public statement that the two men are not the same person. Of course, Tony Liggett omitted these key details. Fourthly, Liggett connected Allen to Bridge Guy by falsely claiming that Allen admitted wearing a black or blue Carhartt and a head covering. Allen told investigators he did not know what he was wearing. Do you see? So this is a lie. Falsely claiming is a nice way of saying lied. Allen admitted wearing a black or blue Carhartt and a head covering. Lie. Allen said he did not know what he was wearing. Although Liggett used Allen's wife's statement that Allen currently owned a blue Carhartt as a nexus to his home, Tony Liggett omitted the fact that she said she purchased his coat a couple of years ago. Had the court known Allen simply admitted owning a blue or black coat, as he does probably every other 50-year-old man, it would have known that there's no connection between him and Bridge Guy. 2, Detective Liggett's omissions and false statements recklessly misled the judge. Any reasonable person, and remember, preponderance of evidence, that any reasonable person would have known the judge would wish to know that Betsy Blair's description of Bridge Guy in the car at CPS did not match Allen or his car. In 2017, Carbaugh described a man walking down the road as only muddy, wearing a tan jacket, not a blue jacket like Bridge Guy. 3, Blair did not believe she saw the same man that Sarah Carbaugh saw. And 4, Allen never said he wore a blue Carhartt or a head covering like Bridge Guy. He bought his blue Carhartt a couple years before 2022, which is 2019-2020. The omitted and false information strikes at the heart of Liggett's conclusion that Allen was the man on Liberty German's phone. The state's probable cause relies on a tight timeline, making Allen the man the 4 girls saw on the trail, Blair saw on the bridge, and Carbaugh saw on the road. Any judge would want to know if witnesses described someone else or someone other than Allen, his car, or Bridge Guy. Moreover, The fact that Liggett lied twice in the affidavit about the connection between Allen and Bridge Guy, i.e., the blue jacket, shows more than reckless disregard for the truth. These falsehoods were directed at connecting Allen to Liberty German's video, which would otherwise include any white male. Now, you see here's where we get to the intent, because remember, the preponderance of evidence, you don't have to show that the intent was to mislead. But here in this paragraph, we do actually touch upon that intent, that these lies point to intent to mislead the judge. With the omitted inaccurate evidence, the affidavit was insufficient to establish probable cause, according to these attorneys. Okay? The state is left with Doolin's report claiming Allen told him he was on the trails between 1:30 and 3:30 and saw 3 girls, not 4 girls, like those who thought they saw Bridge Guy. During his October 13th, 2022 interview, Allen admitted wearing blue jeans and owning a gun, knives, and a blue or black jacket, walking out to the first platform of the bridge to watch fish. But Allen does not look anything like the person Betsy Blair saw on the bridge. Also, his car is a different color and shape than the oddly parked car that Betsy Blair saw. And the man that Sarah Carbaugh saw walking was most likely not even Bridge Guy. If Allen being on the trail within the same 2 hours the girls were abducted is enough for a warrant, law enforcement would have obtained one for Allen's home in 2017. The error requires reversal. A court must suppress fruits of an illegal search, and this is called fruit of the poisonous tree. We all here need to be very familiar with that phrase. Fruit of the poisonous tree. The fruits of an illegal search must be suppressed. The state's entire case is built on Liggett's half-truths and outright falsehoods. Without the gun seized in the search, there's no opinion from Oberg upon which the state arrested Allen. Without the arrest, there are no confessions. If the warrant was illegal, the state has no case. Even if the court finds the confession was not the product of solitary, Allen is still entitled to a new trial. Before a constitutional error can be held harmless, the court must find it was harmless. Remember, beyond a reasonable doubt. We covered that before. Without the fruits of this illegal search, the gun, a casing in a Hope box, the Carhartt, the knives, and computer, the state cannot prove that the jury would have convicted. At a minimum, Allen is entitled to remand for a Franks hearing. Even if Allen's exhibits to the Franks motion did not prove by a preponderance that Liggett deliberately or recklessly falsified or omitted material information, they entitled him to a hearing. A defendant who makes a substantial preliminary showing that an affidavit included a false statement or reckless omission necessary to probable cause is constitutionally entitled to challenge the warrant at a hearing. To meet this showing, the defendant need not present conclusive proof, but must support their accusations with evidence and citations to the warrant application. Here, the court's denial, and this is Judge Gull's blatant exercising of power and bias from the bench. Her denial of a hearing was legally erroneous because Richard Allen made a substantial showing. Allen supported his claims with depositions, police interviews, and reports. Allen made specific arguments citing Liggett's application, and in a final motion, Allen reiterated those points, urging the court to compare the affidavit with Betsy Blair's and Sarah Carbaugh's interviews. The trial court was willing to schedule a Franks hearing when Allen was represented by the Fort Wayne attorneys, Scrimmin and Labredo, but refused when the original attorneys, Baldwin and Rozzi, were reinstated. Allen's constitutional protections are not contingent on who his fucking attorneys are. Oh my God. Bruh.
Bruh.
Okay. So we got that going. How's everybody doing in the chat? We got through the initial points made in the appeal about this issue. Okay, issue number 1, the admitting of evidence from a false search warrant, false probable cause affidavit, and denial of a Franks. So that's issue number 1 in this appeal. Now, I want to get briefly to take a look at the state's response to this, because you guys are going to laugh on this. Okay, it's laughable. Let's see, here we go. Yeah, this is the state's argument here. Look, give me a moment to get some chocolate. Here I go. Okay, that was quick. I'm going to make this easy for you. I'm going to sum up the state's filing here, or state's response, in 2 words. I'm gonna sum up the state's argument in 2 words on this point. And the state's argument is nuh-uh. That's it. That's all they got. Like I said, remember what we all said when this response dropped? Everyone said, "God damn, that's extremely thin. That's extremely weak." State's got no arguments to any of these appellate points here. All right, so here's what they say. They say, nuh-uh. They say, the court properly admitted evidence found pursuant to a valid warrant search of Allen's house. Okay. Okay, they say, not only that, Allen did not preserve this issue for appeal. You can't even talk about this. So they say, nuh-uh, we can't talk about that. Allen's Fourth Amendment challenge to the admission of this evidence suffers from multiple issue preservation problems. Firstly, Allen waived this issue entirely by failing to object to the evidence at trial. Then they say, moreover, the Fourth Amendment issues generally are not subject to fundamental error review because they do not undermine guilt. Fundamental error review is available only when a defendant claims fabrication of evidence or willful malfeasance by the investigator's office, investigating officers. Well, that's what I'm claiming. God damn it, that's what I'm claiming.
It was our job to help law enforcement.
This is bullshit, a lot, though.
That's exactly what I'm claiming. I'm claiming fabrication of evidence, fundamental error, and willful malfeasance. Now, just because these goddamn appellate attorneys ain't got the balls to say it, will say it, okay? You fabricated evidence, you destroyed exculpatory evidence, and you exercised a willful malfeasance since 2017, and the day you decided to go bury this case using Richard Allen, you've exercised nothing but malfeasance, corruption, conspiracy, collusion, and cover-up. There is no claim of fabricated evidence here. Yeah, that's because I ain't the lawyer. Allen's assertion that Detective Liggett recklessly made false statements or material omissions is not a claim of willful malfeasance. Only deliberate lies or intentionally misleading omissions could constitute willful malfeasance. So we'll leave that to the lawyers to figure it out, okay? And these judges, but seems like what was just proven were deliberate lies and intentionally misleading omissions. I mean, the 1965 comet, come on, dude. The 1965 comet that's not black seems like a material omission, seems like intentionally misleading by omission of that fact or detail. The only false statements or material omissions identified by Allen were Blair's description of Bridge Guy, her disagreement with the Carbaugh sketch, Blair's description of the car parked at the CPS building, and Carbaugh's description of the man she saw walking. But that's the whole damn case, bro. Finally, to the extent Allen suggests that success on this issue results in the suppression of his confessions, that claim is doubly waived. First, although Allen challenged the admission of his confessions below on other grounds, he did not raise any Fourth Amendment challenge to their admission or object on the basis that they were the fruit of an unlawful search. Because Allen did not object to the admission of statements on Fourth Amendment grounds in trial court, he is precluded from challenging their admission on that basis for the first time on appeal. Allen does not explain how volunteered statements made to his family, doctors, and correctional staff more than 5 months after the search of his house, after he had been advised of his rights, appointed counsel. Well, was he advised of his rights, by the way? Curious that portion of the interview is deleted. Appointed counsel. Yeah, and by that appointment of counsel, remember that appointment of counsel, that first lawyer who they didn't put into the loop? Remember his very first lawyer? They didn't put into the loop. They had the hearings without that first lawyer. Have we all forgotten about that? That's a whole other ballpark, right? And the court found probable cause to support his arrest. Yes, under a deceptive probable cause affidavit could constitute a fruit of that search. So this is all a bunch of circular reasoning. The closer you read this brief of appellee, it's very circular. Allen has not shown that probable cause for search warrant was predicated on false statements or material omissions. Probable cause exists to issue a warrant when the totality of the circumstances set forth in the affidavit demonstrates a fair probability that the evidence of a crime will be found in the location. There you go again. Remember I said before, totality of the circumstances. This is the state's entire case with Richard Allen. So now the probable cause, now you're saying the probable cause for Richard Allen exists because of the totality of circumstances. Search warrants are presumptively valid, and in assessing whether an affidavit established probable cause, doubtful cases should be resolved in favor of upholding the warrant. So now it's saying you have to presume that Tony Liggett's telling the truth, presumptively valid. So don't worry about the facts of the matter. Just consider that we're considering the totality of the circumstances, and search warrants are presumptively valid. And if you're doubting, you have to resolve it in favor of upholding the warrant. So you see what's being done here? But a defendant may invalidate a warrant by proving by a preponderance of the evidence that the affidavits used to obtain the warrant contain perjury by the affiant or reckless disregard for the truth by him, and the rest of the affidavit does not contain material sufficient to constitute probable cause. Then that's exactly what is being argued. So it's odd that they include it here, but they only do that because they're going to try to twist it. But a defendant does not receive a Franks hearing unless he first makes a substantial preliminary showing that both the affiant knowingly or intentionally or with reckless disregard for the truth made false statements in the affidavit, and that those false statements were necessary to the finding of probable cause. Well, that's exactly what they just argued. But look at what they do now. You can't make this shit up. So now they say mistakes and inaccuracies of fact stated in a warrant affidavit will not vitiate the reliability of the affidavit so long as such mistakes were innocently made. Innocently made. Bruh. So now, oh, oh, please, Tony Liggett innocently omitted this very relevant information, and he innocently lied about these. These are innocent mistakes. So, like I said before, look at. So they say, don't worry, they're presumptively valid, and everything should be held or resolved in favor of upholding. And don't worry, it was an innocent mistake. I'm not lying. Yes. This is the response from the state to the issue raised in the appeal over this probable cause. It's unbelievable. It's unbelievable. It's unbelievable. Innocent mistakes. Uh it's innocent mistakes. Uh, they're presumptively valid, and you should resolve this in favor of upholding the warrant. It's just an innocent mistake that's presumptively valid. The presence of intentional or reckless inaccuracies alone is insufficient to invalidate the warrant. Probable cause must no longer exist after those inaccuracies are excised from the affidavit. Again, they're stating what's already been stated. So in other words, if you correct the inaccuracies and then excise or remove the falsehoods from it, probable cause doesn't exist. And that's exactly what's being argued by Richard Allen's appellate attorneys. And here they're repeating that, but now they're going to twist it. They're going to say, although it's not practical for police to include every piece of information relating to an investigation in a probable cause affidavit. So now they're insinuating here, oh, we'd have to write 30,000 pages of an affidavit. No. No one mentioned every piece of information. What is mentioned are key details that any reasonable person who's the judge would have wished to know or known. An affidavit should include all material facts, which includes those that cast doubt on the existence of probable cause, again, repeating the very statement made in the first filing. Therefore, a defendant may also challenge a warrant by claiming the affidavit omitted material information, a reverse Franks claim. To invalidate a warrant based on alleged omissions, the defendant must show that the police omitted facts with the intent to make or in reckless disregard of whether they thereby made the affidavit misleading, or two, the inclusion of the omitted information renders the affidavit insufficient to establish probable cause. And that's this entire page, except for the words, these are innocent mistakes. The rest of this page is all repeating what's already been stated in the appeal. But here we go with the gaslight. The affidavit did not contain false statements. So they argue that Liggett's representation that Sarah Carbo reported seeing Muddy Bloody Man wearing a blue-colored jacket and blue jeans was not false. Okay? They say Allen's claim it was false is based on Carbaugh's June 7th, 2017 interview, where she is only heard describing the man as muddy and not bloody. And she said he wore a tan or lighter colored coat with a dark hoodie or sweater underneath it. Okay, check that out. So you're telling me in the date closest to the murders, on the date closest to when she would have seen this and experienced this in June 7th of 2017, she is only heard describing the man as muddy and not bloody. And she's saying he wore a tan or lighter colored coat with a dark hoodie or something underneath. And drop down to the bottom here what I highlighted. Look at this. Carbaugh believed that she used the term bloody once in the first interview, but that it could not be heard on the video because she was mumbling. But even worse, she also explained that at least 1 hour of her second interview with police was not recorded.
Prof is a fucking terrorist.
It's not productive. It's kind of gross and icky. And I feel like it tells us more about them than the people they're trying to degrade. They're always trying to degrade someone.
Bruh.
You can't make this shit up. Because she used the word bloody once, but I was mumbling so you couldn't hear me. And by the way, at least an hour of my other interview is deleted, so it wasn't recorded. So everything I said during that hour, and then the one word I mumbled, which was bloody. Oh man. Okay. Similarly, in Carbaugh's second interview, she corrected her previous inaccurate statement that the coat was tan. Interesting. So wait. So how is that inaccurate? So she says the coat is tan with a darker hoodie or something under it. That seems pretty fucking specific in June of 2017 to be saying, okay? But now you're going to tell me that in her second interview, she corrected that inaccurate specific statement and said that the man wore a blue coat with a brown or tan sweater underneath. So she alters it. She flips shit around, right? She also told police the man in the bridge guy photo was the man she saw on the road, and the man was wearing a blue coat. So you see, now they're telling on themselves that she only changed and flipped this shit around after she saw the bridge guy imagery. She saw the bridge guy video or whatever. And she's like, oh yeah. Yeah, actually, I have to correct what I first said because actually I saw that guy because I want to feel important. So now I'm going to say not only was he not muddy and in a tan, now I'm going to say he was bloody and in blue because now he specifically matches both in the visuals and in some sort of crime line scenario. That guy probably would have been bloody after cutting some throats. So now I'm going to say he's bloody instead of muddy, and that he's got a tan on the inside and blue on the outside rather than tan on the outside and blue on the inside. I'm going to totally change my entire fucking story now to get to be important. And then they double down on this one. Check this out. Then they say, not only can he show that Liggett was reckless or whatever, but law enforcement, this is a particularly difficult case, and this case was large and spanning so many years, and law enforcement interviewed huge numbers of witnesses, and many of these interviews took place years before Liggett was writing this affidavit, so he may not even remembered that Sarah Carbaugh had once described the coat as tan, and that she had not said bloody. He didn't remember. So remember, like, because it was like they say, it was a innocent mistake, right? It was an innocent mistake, and he didn't remember because it was a difficult job. This is their, this is the legal reply to the appeal. You guys get that? This is the only state reply to the appeal. This is their legal take. It's innocent mistakes. He's got bad memory. It's a difficult case. And she changed her story, sure, but whatever. And they said, and just in case you don't believe all that, let's just say that even if the allegedly false statements were corrected to now be true statements, so they're saying they're agreeing there's false statements. Okay, even if there's allegedly false statements were corrected to be true, as Alan suggests, a probable cause would still exist. Okay, so let's see. So if we suddenly make Sarah Carbon not see Richard Allen at all, okay, let's say in this probable cause affidavit, you've got Sarah Carbon's entire thing goes away because it's corrected. Okay, so now she doesn't see nothing. Okay. Or if she sees what she now describes, that means she sees someone else, which is exculpatory. Okay. And now if Betsy Blair is corrected, and if the blue Carhartt is corrected, all of a sudden Richard Allen is not on 300 walking to his car. And then all of a sudden, Richard Allen is also not parked over there at the CPS. And then also Richard Allen is not wearing the same clothes as Bridge Guy. So you're saying to me with all of those corrections, probable cause still exists? How? All right. And now we're going to material information defeating probable cause was not omitted. So now they're admitting that there's material omissions that might defeat probable cause. So let's look at here. Allen did not show that these omissions, like Betsy Blair's description of the car and details of her description of the man, everything that makes Richard Allen Bridge Guy, were inconsistent. Allen did not show that these omissions were designed to mislead or made with reckless disregard about whether they would mislead, nor did he show that the inclusion of this information would have defeated probable cause. Bullshit. Bullshit, because if Betsy, think about it. Guys, if Sarah Carbaugh doesn't see Richard Allen, if Betsy Blair doesn't see Richard Allen, all of a sudden, the only people that see Richard Allen are the girls over at Freedom Bridge. So now you don't have Richard Allen entering the crime scene as Bridge Guy, and now you don't have Richard Allen leaving the crime scene as Bridge Guy. So do you understand what I'm saying? If Betsy Blair's descriptions, if Betsy Blair goes away, if Sarah Carbaugh goes away, then you're only left with the little girls. Are you telling me that we still have probable cause without Betsy Blair or without Sarah Carbaugh? Come on, man. I feel like Joe Biden. Come on, man. Come on, man. Bruh.
Bruh.
It's not productive. It's kind of gross and icky.
I'm speechless. I'm literally speechless. I mean, I wonder if all of you guys understand. I wonder if you all see this, what I'm seeing. Okay. Sarah Carbaugh's whole deal goes away. Betsy Blair's whole deal goes away. You now no longer have Richard Allen entering the scene or Richard Allen leaving the scene. All of a sudden, you don't have probable cause to Richard Allen. Hello? And they go through this bullshit. They're downplaying the significance of the details that Carba. So what they're doing in this section, they're taking the details of what Carba and what Betsy Blair provided, and they're trying to minimize the significance of the details. Because remember, in the other document we read, the bar here is that you cannot omit details that would have made things different. So now what they're doing is they're breaking down the details and minimizing them to say, oh, those details don't matter. It's more about the general thing. But there is something down here at the bottom I want you guys to see. So check it out. Hey, thank you, Deb. Yeah, I'm going to need some right now. Deb, I need to pause again. We're getting to the 2.5 hour mark. I'm running out of steam. But look, thank you, Deb. Okay, let me see. Boom. Deb731. For more chocolate, you're going to need it. Oh, my God. I need it now. Okay. The reason I'm pausing on this page, this bottom section, I think is really important because let's read through it, okay? It says here, this is footnote number 9 on page 39 of the state's response right here. It says, although not mentioned in the probable cause affidavit, Rayleigh Voorhees testified at trial that she also immediately recognized the picture of Bridge Guy as the man the girls encountered on the trail. So listen to that phrase, okay?
I'm legally blind.
Once again, Rayleigh Voorhees testified at trial that she immediately recognized the picture of Bridge Guy as the man the girls encountered on the trail. So, okay. So we're showing Sarah Carba the picture of Bridge Guy. Yeah, that's who I saw. We're showing Betsy Blair the picture of Bridge Guy. Yeah, that's who I saw. We're showing the girls the picture of Bridge Guy. Yeah, that's who I saw. At what point are we now leading the witnesses to agree with that's who we saw? We're showing, so we're getting the picture of Bridge Guy. We're putting it in the girls' faces. We're putting it in Carbo's face. We're putting it in Blair's face. We're putting it in the little girl's face. We're putting all the picture of Bridge Guy, shoving in all their faces. And they're all eventually saying, that's who I saw. That's who I saw. Remember when I said these lying ass witnesses? Okay. Who here believes that all of these people saw Bridge Guy? And how do you explain the fact that they all described him extremely differently? Some described him as young, some described him as old, some have described him as poofy, brown, beautiful hair. Some described him as old, gray hair. Some described him as tall and muscular. Some described him as not tall. Some described him as older, like the old guy sketch that we've come to know. Some and all black, all blue. What's going on here? But they say this created a reasonable probability that Allen was Bridge Guy and therefore the murderer, regardless of any discrepancies between Blair's description of the man she saw and Allen. It is not particularly significant that Blair thought Bridge Guy looked younger than Allen's age or had longer hair than Allen. Allen's appearance might be significant to the existence of probable cause had he not placed himself on the bridge at the same approximate time that Blair saw Bridge Guy there. But Allen's placing himself on the bridge at the right time to be the man Blair saw, there by itself, creates a solid foundation to reasonably believe that he might be Bridge Guy, regardless of any discrepancies in the description of his age or his hair or his appearance or clothing. I mean, it's something else, isn't it? So then they go to downplay all the witness descriptions, which, if you remember back to that probable cause affidavit, the witness descriptions make up like 2/3 of the damn probable cause affidavit is all the witness descriptions. Well, all of a sudden, they all don't matter. Like I said, this is a downplay. And now, regarding his car, they try to downplay this. They say the significance of the information from Blair and Wilson was not that they had identified the car as Allen's, nor did the affidavit misleadingly suggest that they had. Rather, the significance was twofold. Between 2:10 and 2:15, the time when Bridge Guy was encountering Abigail Williams and Liberty German on High Bridge, and Allen said he was parked at this location, that there was no other car parked there. What about the Comet? Thereby reducing likelihood that someone other than Allen was also on the trail at that time. And the car was backed up right next to the building, suggesting an attempt to conceal the car's presence or identity. There you go again with how is backing a car in a sign of guilt? Okay, so now we're going to throw that in. So let's just scratch it out because it's total bullshit. Let's go back to this one. There's no other car parked there. That's the significance. It doesn't matter that they identified a different cars. Well, hold on. Let's say both witnesses are correct. What if there is a Terry Wilson type of vehicle? And what if there is a Betsy Blair 1965 Mercury Comet type of vehicle? All of a sudden now we have two vehicles? How do we know the times to be specific? What if one vehicle had left, Richard Allen, and let's say then a 1965 Mercury Comet that's not black pulls up? Maybe the killer is in a 1965 Mercury Comet looking vehicle. All of a sudden, you got someone else out there, right? You got a third party. I think it is significant. Consideration does not remove probable causes. Search warrant was valid and the evidence was properly admitted. So that's the other. Nuh-uh. So give me a moment here. I'm going to do what Deb recommends and get myself some chocolate. Just give me a sec. Let's do this. Chocolate time, Deb. All right, that's as quick as I could possibly move. All right, so concerning, right? So now we're going to go through this reply here where Richard Allen's attorney clapped back. This is the clapback. So after reviewing the state's weak ass excuse making, minimizing, I mean, you think about the narcissistic profile, right? They're basically establishing a profile of a textbook narcissist. They're minimizing, right? They're minimizing. They're making excuses. They're deflecting. They're denying. Nuh-uh. Typical textbook narcissistic personality traits from the state. So here they get bitch slapped. It says the trial court committed reversible error by admitting evidence seized from the unconstitutional search and by denying Richard Allen a Franks hearing. Allen's exhaustive pretrial litigation preserved the Fourth Amendment issue. The state contends that Allen waived his Fourth Amendment challenge by stating no objection when individual exhibits were offered at trial. But the argument fails on three independent grounds. So let's look at these because remember, that was a big sticking point. It was one of the only legal arguments, it seems, that the state actually made was this Fourth Amendment argument. So let's look at it. The purpose of the contemporaneous objection rule was fully satisfied. The overriding purpose of the requirement is for a specific and timely objection is to alert the trial court so that it may avoid error or promptly minimize harm. Courts should not apply the rule with unyielding rigidity when this purpose has been met. Allen's attorneys exhaustively litigated the suppression, filing multiple motions supported by more than 130 exhibits. After the court denied the motion to suppress without a hearing, Allen renewed it twice more, which the court again denied. Throughout the extensive briefing, Allen repeatedly emphasized Liggett's omission of Blair's description and the falsehood about Carba. Allen did not idly sit by only to cry foul when the court ultimately renders an adverse decision. There's absolutely no strategy for Allen's attorney's failure to object to evidence so that they so aggressively litigated. For judicial efficiency, the issue should be resolved now rather than on post-conviction relief. Secondly, the recent amendment to the evidence rule confirms that Allen's challenge is preserved. The Indiana Supreme Court amended Rule 103B to clarify that once the court rules definitively on the record, either before trial or at trial, a party need not renew an objection or offer of proof to preserve a claim for error for appeal. This includes a ruling on a motion in limine. The state urges this court to ignore the amendment because it was not in effect at the time of trial, but because the rule governs what is required of an appeal, it should be applied to Allen's pending appeal. At a minimum, the amendment reinforces the DRC principle that the contemporaneous objection rule must not be applied with unyielding rigidity. Thirdly, the Franks hearing denial is a pretrial constitutional rule requiring no trial objection to preserve. The trial court did not merely admit evidence, it refused to hold a Franks hearing. Once the ruling was made, no further objection at trial could undo it. The state cited no authority requiring a defendant to object at trial to preserve the denial of a Franks hearing. Detective Liggett included multiple deliberate falsehoods in the affidavit. You know what that word deliberate falsehoods means? Lies. Lies.
It was our job to help law enforcement.
Bruh.
The state argues that Liggett's representation of Carbaugh's account that she reported seeing a muddy, bloody man wearing a blue-colored jacket was not a false statement, and that any inaccuracy may have been a mistake. This argument also fails. Liggett did not just represent what Carbaugh saw, he represented when she said it, swearing she gave her description in 2017. The temporal representation added a veneer of reliability because a description given close in time to the murders carries obvious weight. The state concedes that in 2017, Carbaugh never described the man as bloody or wearing a blue jacket. She described him as muddy and wearing a tan jacket. The evolution of Carbaugh's statements made the affidavit more misleading, not less. That Carbaugh's account changed over the years from muddy to muddy and bloody and from tan to blue jacket is precisely the kind of information the issuing judge needed to assess her credibility. It's a good point there. This is something the reasonable judge would have wanted to know. Police officers seeking a warrant should provide the magistrate or trial judge with all information at their disposal concerning a source's reliability. Instead, of course, Liggett only included the version of Carbaugh's account that fit his conclusion and falsified when she gave it. It's also implausible that Liggett made an honest mistake. It was just a mistake. Liggett was the officer who interviewed Carbaugh in 2017. He also admitted that Betsy Blair did not believe she saw the same man Carbaugh did, resulting in a 2019 ISP press release that the man Carbaugh saw was not Bridge Guy. It's no coincidence that the false statement and the omission bolster Liggett's conclusion that Blair and Carbaugh both saw Bridge Guy. So you see what's happening, just like it was mentioned previously, that you cannot alter and omit key details and facts to fit your version of what you want this story to be when you're providing the or sending this to the judge. The Carbaugh falsehood is not the only one in the affidavit. The state does not dispute that Liggett falsely stated in the affidavit, written the same day Allen was interviewed, that Allen admitted wearing a black or blue Carhartt jacket. In fact, Allen told investigators he did not know what he was wearing that day. Even if Allen did not argue this specific falsehood in his briefing below, the court may consider it in response to the state's appellate argument that Liggett simply forgot. The common thread is plain. Liggett's affidavit forgot every single fact that did not fit his theory that Richard Allen was Bridge Guy. Betsy Blair's omissions and omitted descriptions were made with reckless disregard for the truth because they directly negated the warrant's core finding that Allen was Bridge Guy. That's why he did that. That's why he omitted it. While the state concedes that Liggett omitted parts of Blair's identification, excluding Allen or his vehicle, the state argues that Allen failed to show these were omissions made with the requisite intent to mislead or with reckless disregard for the truth. The state is wrong on both the law and the facts. The state misreads State v. Allen as holding that intent to mislead cannot be inferred from omissions themselves. But that case rejected the proposition that any omission shows such intent. That is not that a material omission cannot support that inference. Settled Indiana law provides that omissions are made with reckless disregard for the truth when an officer withholds a fact in his ken that any reasonable person would have known that this was the kind of thing the judge would wish to know. Blair's omitted descriptions were exactly the kind of fact that the judge would have wished to know. In fact, Betsy Blair's descriptions directly undermine the affidavit's central conclusion that Allen is the individual on the bridge. Liggett swore under oath that he was able to corroborate information that Allen was at the trails at the same time Libby and Abby were, and the individual in that picture matches the description of Richard Allen. But Liggett knew that Blair, the only witness who was on the bridge at the same time as the man described, or as that man described someone who did not match Allen at all in age, in height, in hair, in facial. He withheld that contradictory evidence while including only the portions of other witnesses' accounts that supported his conclusion. That selectivity was not neutral. Liggett included every description pointing towards Allen while suppressing every description excluding him. You see what's going on here? Had Blair described someone who looked like Allen or his car, there's no doubt that her description would be front and center of the affidavit. Now, the state tried to minimize and contend that Blair's descriptions are immaterial because the timeline is so tight. Allen had to be bridge guy, regardless of Blair's account. But that argument assumes its own conclusion. The tight timeline holds together only if Blair's account is set aside. The fact that the only eyewitness who definitively saw the man on the bridge described him and the nearby car in ways inconsistent with Allen. As I mentioned, think about it. Betsy Blair describes a different car than Richard Allen's car. Betsy Blair describes a different man than Richard Allen's appearance. Therefore, Betsy Blair don't see Richard Allen. This is precisely the type of information a neutral magistrate would want to know before issuing a search warrant for someone's home. Without the falsehoods and with the omissions restored, probable cause evaporates. The state's probable cause theory rested on three pillars: right place, right time, right close. Again, guys, for my audience who don't really like to follow the state's fucking story here, three pillars in the state's probable cause, right? Right place, right time, right clothing. The clothing pillar falls first. Liggett tied Allen to bridge guy through clothing 11 times in the 4-page affidavit, twice falsely, representing that Allen admitted wearing matching attire. In reality, Allen said he did not know what he was wearing that day. He could have worn a blue or black jacket, but also a hoodie or sweatshirt. The blue or black jacket was the glue holding the state's timeline together. Strip away the false claim that Allen admitted to wearing it, and the clothing connection dissolves. Now, the timeline. Blair's omitted descriptions of both the man on the bridge and the vehicle at the CPS lot directly contradict the state's timeline theory. Even the state acknowledges that the discrepancies between Blair's description and Allen's appearance might be significant to the existence of probable cause. Yet the state offers no reasoned basis for setting Blair aside. Blair is not peripheral or unreliable. She is the only person who unquestionably saw the man on the bridge. And the ISP itself validated her account and a sketch in 2019. And in a press release. Liggett hid that validation from the judge. So Liggett hid from the judge that Betsy Blair is the only person who unquestionably saw the man on the bridge, what her description of that man was, the sketch of the man, and the description of the vehicle that was alleged or was tried to be forced on the Richard Allen. Allen also never, quote, placed himself on the bridge at the same time, approximate time, that Blair saw Bridge Guy. 2 days after the murders, Allen told investigators he was at the trails from approximately 1:30 to 3:30. 5 years later, he said it was around noon to 1:30. Similarly, the Harvestor video shows a car whose license plate and driver are both unidentifiable. Even if the car were Allen's, Blair's testimony that the car in the CPS lot was not black and had sharp angles suggests Allen was more likely departing via the farmer's entrance, consistent with his 2017 statement to DeLynn that he parked at the old Farm Bureau building. Stripped of the falsehoods and supplemented with the omissions, what remains is this. Allen took a walk on a trail in the early to mid-afternoon on the day of the murders, owned a jacket that could have been black or blue. That's not probable cause. This case is nothing like Ware v. State, involving law enforcement who omitted an earlier eyewitness ID after excluding the alternative suspect through forensics. They had independent evidence supporting the warrant despite the omissions. Here, there was no independent evidence linking Allen to the crime. Not one tip or witness identified Allen. Think about this. I'm going to read that again for the bloodthirsty, meth-loving, pedal-enabling, sister-loving, cousin-fucking, boot-licking, bloodthirsty demons in the back. In this case, there was no independent evidence linking Allen to the crime. Not one tip or witness identified Richard Allen. As the Indiana Supreme Court has recognized, a neutral and detached magistrate, not a police officer, makes the determination of probable cause. Because officers are engaged in the often competitive enterprise of ferreting out crime, law enforcement cannot simply omit information that casts doubt on probable cause. The appropriate remedy for the improper denial of a Franks hearing is reversal and remand. The state erroneously argues that there's no remedy or harm caused by the trial court's failure to hold a Franks hearing. Again, the state's full of shit. You saw how they said that you can't complain about the Franks after conviction. Did you remember that? Actually, let's pull it. Let's get to that. Who knows what page it's on? We read it here. Oh God, that was the first page I pulled. Look at the bottom. It says, to the extent Allen requests in the alternative remand to hold a Franks hearing, he does not cite authority for the proposition that such a hearing can be held post-trial while an appeal pens. He's also not identified any evidence he could present at a hearing beyond the 133 exhibits he already submitted to trial court in support of his motion. He had a full and fair opportunity to create an evidentiary record to support his claim, and this court has sufficient information to conclude that Allen cannot meet his burden of proof. So you see this claim here, it's in a footnote, which is interesting. That it seems like nothing, but they're basically saying there's no authority for the proposition that a Franks hearing can be held post-trial while an appeal is pending. And their response to that is that this is an erroneous argument that there's no remedy or for harm caused by the trial court's failure to hold a Franks hearing. Courts have consistently reversed and remanded for a Franks hearing. So reverse, remand for Franks. And again, they state that up front. You see where they state up front, they say the appropriate remedy for improper denial of a Franks is reversal and remand for Franks. Reversal and remand for Franks. The state contends that Allen failed to prove by preponderance that Liggett's omissions and falsehoods were intentional or reckless, but that is precisely the showing a Franks hearing is designed to allow a defendant to make. In person, through confrontation with full evidentiary development. The state cannot simultaneously argue that Allen fell short of his evidentiary burden and that he was not entitled to the very proceeding where that burden is tested. A defendant is not required to make two proffers, one to secure a Franks hearing and another to demonstrate what he would have proven at the hearing. Franks and his progeny require no such thing. Ruling for the state would nullify the constitutional protection that Franks established. Allen proffered statements from Blair, Carbaugh, Allen, and his wife, and identified specifically how each contradicted the warrant affidavit. That proffer, at a minimum, called the warrant's validity into serious question and entitled Allen to a hearing. Allowing the state's procedural argument to prevail would mean that any defendant whose Franks challenge is improperly denied before trial has no meaningful remedy after conviction. Let's read that again. Just a moment. Let's read that again. It says ruling for the state would nullify the constitutional protection that Franks established. Allen proffered statements from Blair, Carbaugh, Allen, and his wife and identified specifically how each contradicted the warrant affidavit. That proffer, at a minimum, called the warrant's validity into serious question and entitled Allen to a Franks hearing. Allowing the state's procedural argument to prevail would mean that any defendant whose Franks challenge is improperly denied before trial has no meaningful remedy after conviction. And they reiterate that the remedy here for the denial of the Franks hearing is reversal and remand. Courts have consistently reversed and remanded for a Franks hearing. See People v. Zymontas, U.S. v. Felton. Honestly, I think this is the most likely outcome of this appeal. Reversal and remand for Franks. I honestly believe this is your most likely scenario, that we'll be looking at a reversal and then a remand for a Franks hearing. It would be interesting to see whose court that lands in. Which judge, if this is reversed and remanded for Frank's hearing, which judge is that Frank's hearing going to sit in front of? I guess it depends on when it happens, because Judge Fran Gull is still sitting her ass in Allen County. And when she's gone, she'll be replaced. So I guess it depends on timing. Because maybe it's possible that if this was reversed tomorrow, or let's say Tuesday, since we have a holiday, this was reversed and remanded on Tuesday and they schedule it 3 months out, maybe it goes back to Fran Gull and she's forced. Who knows, man? Who knows? But that catches us up to speed with the issue of the probable cause affidavit being full of lies and omissions and the improper denial of a Frank's hearing. And I hope that all of you now have a much better handle on this component of the appeal. Remember, there are 3 pillars of this appeal. I almost would like to just remind us here of what they are. Our 3 pillars whether the search of Allen's home was unconstitutional and the resulting evidence inadmissible because Tony Liggett omitted or altered key facts in the warrant application, whether the statements or false confessions Allen made while gravely disabled during unprecedented pretrial solitary confinement were involuntary, product of unconstitutional detention and inadmissible, and whether the trial court denied Allen his right to a fair trial to present a complete defense and explain the scene and impeach the investigation. So your 3 pillars being Tony Liggett's probable cause affidavit, false confessions, and the ability to present a complete defense and impeach the investigation. And they included in this the denial of a Franks. And that's your whole appeal. And like I said, we've got 300 issues that could have been at the forefront, and we're only looking at 3. I consider it 4 because I consider part 1 to be a 2-parter. So I think there are 4 issues, and that's the search warrant application, that's the false confessions being admitted, that's the denial of a fair trial to complete a defense, to present a complete defense, and the improper denial of a Frank's hearing. That's my take. But it looks like we have made it through, thanks to my skipping through most of the bullshit, needless words in the state's reply, due to skipping over a bunch of the pointless bullshit. We're already done. But there we've taken a very close look at this issue, and we're going to have one more episode on this appeal, and that's going to be the big picture, because the way they open up these filings, they open up with the big take on the case before they go into each individual pillar. So the next time we cover this, we're going to be doing sort of the prelude to it all, which is the introduction to the filings. And it should be equally infuriating because, as we know, none of this makes sense. None of this makes sense whatsoever. You know what I'm saying? Like, That's what I never understood about these bloodluster demons. If you're an idiot and you believe anything you're told, yeah, you could listen to this Gray Hughes theory of the case, that some whacked out fucking predator, psychotic bridge guy whack job, you know, he comes out there as he wants to seize a crime of opportunity and prey on two girls, but sure enough, he finds two, and he does the exact Gray Hughes scenario. He marches them off the end of the bridge. He somehow, probably with the gun, he forces them down the hill, probably with the gun. He lingers with them for a while. He probably tries to do things to them. Then he chases them across the water. Then he chases them on up the other side. Then he makes them get more naked and struggles with them and ends up killing them. And then he after he's all done for whatever reason, he throws some sticks. Don't worry, they're not formed in sigil like bind rune like formations. They're just randomly fell off a tree or were thrown there because he found them. And then he runs out of there, and he passes the harvester, but somehow doesn't leave his image on the camera, and he gets in his car and goes away. And it's absolutely infuriating every time I hear that scenario because it makes zero sense. Um, could it be possible? Could something like that be possible? You could say possibly. Possibly. If it was a methed out Delphi pervert, rapist type, sadistic motherfucker, could I see something like that being possible? Potentially, something like that. Could I see the crime scene being left the way that it looked? No, because seeing the crime scene photos totally changed the take on it all. It also made the entire community's behaviors and words and allegations and statements and leaks out over the years make sense. And and it just doesn't gel with all of the stories over the years of multiple perpetrators of this pig roast, of the pedophiles involved, of the catfishing, of the geocaching, of the weird behavior of the family members, and all of the shit that we've come to know as a Delphi murders case. The version we're given by the state in this fantasy world scenario makes zero sense. It doesn't align with any rationality based on what we've been given all these years. It's like a fantasy. And that's why it's infuriating to hear it. I mean, you might remember that I said before, when you listen to Nick McClelland's opening and closing arguments, it's probably the most infuriating thing you'll hear. You're like, if you want to pull your hair out, if you want to really feel some anger and pain, go listen to McClelland's opening and closing, especially the closing. Because what they do is they take this sick fantasy imaginary scenario and then they railroad or give tunnel vision to the world and the jury in the way that they frame this. And this is the railroading and the framing. And then in the closing, they retell that story in that sick way and then try to throw it into Richard Allen's lap. And it makes no sense. It's like, bro, none of this makes sense. It doesn't gel with anything we've ever known. And then on no evidence whatsoever, you're trying to throw this in this guy's lap. Like, how about prove your case? But this is what we're given. So anyway, I hope everybody had a happy Friday night. I mean, not that this is the happiest of content, but I guess it was good to see everybody here. It's been a while. Hey, I'm going to try to do shows way more often. I truly apologize for the long intervals. I've been really busy, been having a lot to do, and I've been taking a little bit of a break intentionally, but I'm ready to do more. So I'll be ramping it back up. Um, but hey, I appreciate everyone for being here. And if you're new here, I want you to know that we love the comments in the comment section. Please do me a favor and leave me a comment. And also, please follow the suggestion of the scrolling banner down below, which says, please support this channel by sending a Cash App and join me at Substack and Facebook. And please remember to subscribe and hit the like. So I truly appreciate all your financial support. Um, the donations have slowed down on the channel, and I'd appreciate support on the channel. And I'll be getting back active to give you guys some more. But please support the channel if you're able to through Cash App and also through subscribing to me over at Substack. I love to piece together articles periodically for you at Substack. Please join me at Substack. I have a couple free Facebook groups. You can join me at Facebook and just hang around and let me have some comments down below. I like to hear what you have to say. So that's what's up. Now, let me see if I can read some chat. Let's say goodbye to everybody before we get out of here. Let's see. All right, we got. It's going to be hard. A lot of people. All right. Firstly, let's see. We had Mustang. What's up, Mustang? Thank you for being here, Mustang. Critter Mama. Criminal Sociology. Pertinent. Come on. Scroll, scroll, scroll. We had Anarch here. That was super earlier. Okay. Nicole Watt was here. Ninja Warrior Assassin. Okay. Who did I miss? David Rogers was here. Oh, hey, Christina. Monday. Brittany Renee. 4 pit bulls across America. Rebecca Ann. Court of Public Opinion 2024. Who's Your Daddy 11. Violets and Grace. Arthur Claremont. Let's see who else I missed. Brenda Mays. Peggy O. Digital. Swade Smith. Probably skipping over a bunch of people. I'm trying to see here. Let's see. Okay, we got Carla Ann. Good to see you. Who else here? Nancy Drew 101. American Night Mom. Hey, y'all. Okay. We got Becky B33. Ropes Gal. Nancy Drew 101. Okay. Matt Payton. What's up, Matt Payton? MJ Lewis, 1964. Mercy Choke. Terrible name. All right. Dennis McKean. Dennis McKean. Zaddy's here. Hey, Zaddy. All right. We got For Babyish. All right. I think I caught everybody pretty much. Let me know if I missed you. Christopher, 88A. He's probably missed a lot of people. Sheridan Tibbetts. Matt Payton. I feel a sneeze coming. Uh-oh. That was rough. That was rough. It's better though. So thanks everyone for being here. Good night to you. Happy Friday. Hey, have a nice holiday weekend. You got your Monday off now. This was Delphi. The appeal won. Court wrongly admits evidence from a false search warrant affidavit and denies Franks. So I hope you found this enlightening. We have several more in this series. If you look at the most recent live streams, you'll see that we're methodically going through this entire appeal. Methodically, probably going to be about 12 hours of content in total so that you can get a really good handle on the entire appeal and maybe get some confidence because things are looking good. Also, please remember this. Let's not forget I have it somewhere here. The good news that, let me see, is it here? Yeah, the good news. The Court of Appeals of Indiana appellate, appellant has filed a motion for oral argument. Having reviewed the matter, the Court of Appeals of Indiana finds and orders as follows. Appellant's motion for oral arguments is granted. The oral argument is scheduled for the following date, time, and place, and that's Monday, September 21st, 10 a.m. Monday, September 21st, 10 a.m. Supreme Court, State House, room 315, Indianapolis. Okay? Each side will be allotted 30 minutes for argument. So September 21st is the next date on the calendar, and looks like this is the reason to be encouraged because we got oral argument. And like I said, I think things are looking really good. It's a reason to be encouraged. And let's just hope that transparency reigns supreme here. I don't know if you saw in that, but it said, yeah, there's going to be cameras. So it should be interesting. So we have from now until September 21st to do absolutely nothing. Wait, hurry and wait, hurry and wait. Okay. So hurry and wait, guys. It's May. So it's what, June, July, August, September, 4 months of waiting for that. Okay. 4 months of waiting. So enjoy your night, enjoy your weekend. I'm going to relax now. But it was a really nice show, and I so appreciate the live chat and everyone coming in to have a nice time, chat with each other. So thanks for being here. Please return. I'll do some more live soon. So I'll see you guys then. I got a special surprise for you in a week, by the way. So that'll be 1 week from now, next Friday. I have a nice show planned. So plan to be here next week at this time. I'll try to do a couple shows in between. So that being said, thanks, guys. Thanks, guys. I'm out of here. Boom shakalaka. Yeah.
Well, obviously, we have a rapist in Lincoln Park. He's climbing in your windows. He's snatching your people up, trying to rape them. So y'all need to hide your kids, hide your wife, and hide your husband because they raping everybody out here.
It's not productive. It's kind of gross and icky. And I feel like it tells us more about them than the people they're trying to degrade. They're always trying to degrade someone.
Prof is a fucking terrorist. A fucking pedophile, sympathizing fucking terrorist.
It was our job to help law enforcement.
Bye bye, you fucking foe.
Prof is a fucking terrorist.
It's not productive. It's kind of gross and icky.
Prof is a fucking terrorist.
This is bullshit, Alado.
Prof is a fucking terrorist.
It's not productive. It's kind of gross and icky.
It was our job to help law enforcement.
It's not productive.
It was our job to help law enforcement.
It's not productive.
Prof is a fucking terrorist. A fucking pedophile, sympathizing fucking terrorist.